And did you then accept a position as head of security with Busch Entertainment?
Yes, sir, I did.
Let's talk a little bit about that. It's a completely different area from police work.
Yes, sir, it is.
Tell the ladies and gentlemen of the jury what you had to do now in order to get trained on being head of security for such a large corporation.
It's considerably different than being in law enforcement, and the fact that you do not have the powers of arrest. You are basically coordinating security officers to perform tasks to protect the company's resources and to train and make the guest experience at Busch Gardens as good as it can be. So your mission is completely different, and they had classes that were at that time optional. I felt like they were probably mandatory because it was a change of pace for me. So I availed myself as many training programs as I could. I also inherited a very knowledgeable staff, staff of managers, and they were, as far as knowing the mechanics of how to run a theme park and how to run a security department, they were excellent in that perspective. They just needed they had not had the advantage of training schools before, so I tried to encourage my managers to take advantage of the schools that were available for them because the mission is different. You don't realize it when you're a law enforcement officer. You kind of slide into the mindset of arrest powers and the power to conduct investigations. So when you go into something like this here where you do not have those powers, it's almost like like a weight is lifted off your shoulders because you don't want that responsibility. You want to be invisible in your society from the standpoint of being a law enforcement officer. And you don't understand, I didn't understand, the weight that you carry when you have those arrest powers. So it was a pleasant surprise for me and my family when that was ended.
That was a very good job. Director of Security for Busch Gardens, correct?
It was great.
That particular job at the time that you first started did not employ law enforcement officers there at the amusement park, correct?
Yes, sir.
And so what did you do when you came into Busch Gardens with reference to that issue?
The Gardens had a security force of somewhere between 85 and 100 and something security officers. And the turnover rate was pretty high, so it was difficult keeping them trained. So one of the things that you try to do is you try to take a look at what's required of each officer and then provide the training for them so that they can perform those tasks. You find that oftentimes things kind of will occasionally get out of hand. The training method that we used was that if somebody came across an issue, any employee, not just a security employee, any employee that came across an issue, their task was to immediately bring that to the attention of a manager and get a manager involved in it. Sometimes they got beyond the manager level, and then we would have to involve security, and sometimes it got to the point where we needed law enforcement. And when we call them, it was oftentimes a little bit of a delay in their response time, which was they were in the middle of a theme park. Sometimes we'd have 30,000, 40,000 people, and you didn't have the benefit of waiting. So I included a staff. I budgeted for law enforcement, and we tried to keep law enforcement on property so that they could respond to those incidents.
Corporate's desire there at Busch Gardens was for the customer to enjoy the amusement experience. How important was that in your functions as the head of security for Busch Entertainment?
You, as the head of security, you're responsible for the company resources. You're responsible for, if there is an issue, you want to remove it from the view of the guest. So you have to train your employees. The idea is they won't come back if they don't have a good experience. So the objective there is to make their experience as pleasant as possible. So your job, that was what security did. You were present if they had an issue. If they didn't have an issue, we tried to be invisible. We didn't need to be there. We didn't need to get involved. But that's the purpose was. This is a corporation that makes money off a guest experience, and that's what your responsibility is.
And would you, as head of security for Busch Gardens, at times be heavily involved in those instances where patrons were maybe a bit unruly?
Yes, sir. That would. If it was out of control, we would try to keep from involving law enforcement if we could. And I was probably the last one that would get a call, or if I heard it on the radio, then I would respond. And this goes all the way back to law enforcement experience. No matter what you're encountering, your objective is to de-escalate it. You want to get things down to a manageable level, and most times you can. And that's what your objective is. And if you can offer appeasement to whatever the situation might arise. And if necessary, then you would notify law enforcement or eject them from the property.
At the time that you were head of security for Busch Entertainment, was there a beer garden?
Yes, sir, there was.
Explain to the ladies and gentlemen of the jury what the beer garden was at Busch Entertainment.
The beer garden, they were, Budweiser brewed a variety of different beers, and they wanted the guests to have the opportunity to sample them, so they had beer kiosks with free beer. And it was a very popular gathering place on the property. And as you can imagine, it was also a popular place for issues to arise.
Curtis, let me ask you a question. Did you ever find the need while you were a law enforcement officer at TPD to have to use your weapon, fire your weapon,
No, sir.
in the line of duty?
No, sir, I did not.
Did you ever find the need, Curtis, when you were working for 12 years for Busch Entertainment with 30,000 people visiting that amusement park, to ever have to pull your weapon and use your weapon?
No, sir, I did not.
You enjoyed your time as head of security for Busch Gardens?
It was like I said, a change of pace, and it was a much easier job than I had come from.
Your reasons for leaving the Tampa Police Department, what were those reasons? Please tell the ladies and gentlemen of the jury.
I had cancer in 1988, so I was not insurable for about 5 years. So I had had some related health issues, and I had spent 27 years there doing that stuff. It was a very dynamic job. You don't realize the dynamics of it until you're not there anymore. So I was looking around. My wife and I kind of had a retirement plan in mind, and I had then been there for 27. I think I was 51 years old, and I had heard about a job opportunity, and I applied for it.
And you were there at Busch Entertainment.
Curtis Reeves' long resume in law enforcement is going to help him in this case. Imran Ansari is watching along in New York. What do you think? Big drum up. Andrew Mishlove also with us in Milwaukee, Wisconsin. Imran, to you, what, is this going to work? Is this going to help, or will it bite him because he was trained in de-escalation too?
Yeah, Ted, well, you know, the defense has to do this. They have to humanize this defendant before this jury. We see this lead up before we get to the meat and potatoes of what this justification defense will be about, and that will be his state of mind preceding the shooting. But this is necessary in order to lay a foundation of about who this defendant is as a person and also his prior profession. It could come to bite him in the long run, because you would say he has training as to de-escalation and also use of a firearm and when a use of a firearm is proper. But this sort of procedure you have before this jury is the defense letting this jury know who he is as a person, the past law enforcement experience, military experience, and this is the essential for the defense in order to humanize this defendant before that jury.
All right, we'll take a break and come back and pick it up right where we left off. You're watching Court TV. This is your front row seat to justice.
I hated sticking my
courtroom we go. Curtis Reeves on the stand in his own defense. We're picking it up right where we left off. He still has not started to talk about the day of the murder or death.
I think about 11, almost 12.
And so why did you leave Busch Entertainment?
As a manager, you needed to check on your people periodically, and I was having issues that didn't give me the walking and standing on my feet all day long was becoming quite a chore. So I had been through a lot of physical therapy and different strategies to make it better, and they wasn't getting any better. So again, my wife and I were kind of on track for retirement, and we had built a new house in a new location, and it just kind of coincided with the medical issues. In the latter part of 2004, I had been doing a lot of physical therapy 3 days a week for months and months, and the new house was there. It was just a good time to let it go.
And so now, for the next 8 years, you were in retirement.
Yes, sir.
May I approach you? Curtis, I'm going to show you what's been entered in exhibit as, looks like it's number 23, and ask you to take a look at that exhibit. Would you please tell ladies and gentlemen the jury what that exhibit is?
This is a concealed weapons or a firearms license for the state of Florida.
And was that your concealed weapons license for the state of Florida?
Yes, sir, it is.
And was that particular concealed weapons permit active on January the 13th of 2014?
Yes, sir, it was. It looks like it expired in 2017.
May I approach you?
You may.
Curtis, I'm going to show you what's been marked as exhibit number 27 that's been introduced into evidence. It's a state's exhibit. Would you please tell me what that exhibit is?
Okay, this is my ID card, my retired ID card from the City of Tampa Police Department, showing that I retired from the Tampa Police Department on September 30th, 1993.
Did you have both of those items on your person on January the 13th of 2014?
Yes, sir, I did.
May I approach you?
You may.
I'm going to show you what's been marked as State's Exhibit number 25 that's been introduced into evidence. I'm going to ask you to take a look at that particular card, and please tell the ladies and gentlemen of the jury what that card entails.
This is a firearms proficiency verification card from the state of Florida. This is a requirement for it's called HR 218, which is a federal firearms program that encourages retired law enforcement officers to be armed. It's a proficiency test that you have to perform annually to maintain that proficiency. And it says on the front that I'm qualified with both a pistol and a revolver. The difference is a pistol is normally a semi-auto, and a revolver has a cylinder in it. So those are the two things. And you can qualify with any caliber of this weapon, and you're qualified with any semi-automatic or revolver.
And was that particular certificate or that particular permit valid on January the 13th of 2014?
Yes, sir, it was.
And Curtis, did you have this in your possession as well on January the 13th of 2014?
Yes, sir, I did.
You're on that approach. Curtis, I'm going to show you what's been marked as State's Exhibit number 29, and ask you if you recognize that particular exhibit.
Yes, sir, I do.
And what is that exhibit?
This is a badge case that those other credentials were in, along with my retirement badge.
And what does that retirement badge say?
It says C.J. Reeves, Captain, City of Tampa, Florida, Police Department, retired.
Curtis, you heard Dr. Foley describe some of your ailments that were visible on the x-rays here yesterday. Is that correct?
Yes, sir, I did.
And were those the ailments that you had on January the 13th of 2014?
I guess I didn't realize they were that serious, but yes, sir, it is.
And were you having pain as a result of those ailments?
I did have, yes, sir, my legs, my back, primarily, shoulders. It was just, it was bearable. I tried to stay as active as I could, as long as I could. So I tried to take every opportunity to exercise because I saw so many people that had these issues and didn't. So yes, I had those. I was also prescribed an anti-inflammatory, so I took those to help out whenever it got bad.
That cane that you walked up today with, you weren't using a cane back in January of 2014, were you?
No, sir.
Would you tell the ladies and gentlemen of the jury when you first started using that cane that you walked up?
Relevance.
I think it's very relevant.
All right, Sidebar, let's get a break in here. We'll pick it up right where we left off. Stay with us.
Police officers shot
79-year-old Curtis Reeves is facing a second-degree murder charge in the state of Florida for taking the life of a 43-year-old man in a movie theater. They got into an argument over the use of a cell phone, and at the end of it, this man, Chad Oulson, ended up dead, a father of a young daughter. His wife has been in the courtroom the entire time. His wife is there this morning watching the man that took her husband's life on the witness stand, defending himself. So far, we haven't heard anything about the day that the shooting took place. It's all been about the defendant's history as a law enforcement officer and a member of the Navy. Let's go back where we left off. We'll pick it up right there.
Curtis, to get back to my previous questions, back in January of 2013, you weren't using that cane, correct?
No, sir, I wasn't.
And would you, excuse me, 2014. Would you please tell the ladies and gentlemen of the jury when you first started using that cane?
Probably the latter part of 2014. And
when did you start using that cane?
probably a year or two ago. I mean, on a fairly regular basis.
Okay.
Off and on, I had some nerve issues that would make me...
This is going beyond what we discussed at the bench.
So it's the reason, Your Honor.
And it was not constant. It was kind of off and on. So if I was having trouble keeping my balance or walk in a straight line, I would use a cane.
Let me ask you a question. Did you just recently also have surgery on your feet?
Yes, sir, I did.
Okay. And have you been using, at least out in public, the cane a bit more because of that surgery?
Yes, sir.
When you're at home, do you use the cane everywhere you go at home?
Not always. I have a walking stick. Sometimes I'll use that, and sometimes if I'm not having any issues, I'm really not, no, not all the time. If I'm having an issue, yeah, I don't want to fall down, so
Okay.
I'll use it.
And so are you telling the ladies and gentlemen of the jury that some days are good and some days are not too good?
Yes, sir.
Objection, relevance.
Okay. Let's go over some of the things that that Dr. Foley talked about. You've got herniated discs, is that correct?
In my back, yes, sir. I think it starts at the top and goes all the way down to my lower back.
And did you have those herniated discs on January the 13th of 2014?
Yes, sir, I didn't. Yes, sir.
Did you have arthritis and experiencing arthritis throughout your body?
I started really noticing it probably about the time I retired from Busch, about 2004, 2005, when we moved. That's when I started really having some serious coordination problems, I guess you could say. Strength problems.
Did those injuries that you were experiencing, did they cause you pain?
Yes, sir, they did.
And so what would you do as a result of that pain?
Well, you kind of learn how to take care of yourself. If you're going to do something you know it's going to be painful, you either take a leave before you do it or after you finish it, or you don't complete the whole task. You work until you start feeling the pain, and then you stop and then take it up again the next day. So you just kind of learn how to manage it, whether it's your back, your hands, your arms, whatever.
Curtis, excuse me, Mr. Reeves, did you continue to want to do things despite your pain?
Objection, relevance.
Yes, sir, I did. I think that was, I didn't want to get into a position where I didn't have a range of motion or mobility. So I took some of the things that would be normally, that you would normally think would be something that you would do around your house, and taking out the garbage, mowing the yard, trimming the shrubbery. I continued to do that as long as I could.
And do you continue to do those things even as we sit here today in the year 2022?
Not nearly as frequently, but yes, sir, I still do.
And why is it that despite pain, you still do it in the year 2022?
Objection, relevance.
It doesn't keep you young, but it keeps you mobile. I think it keeps your limbs mobile, and it keeps you moving around, and you don't have. I see so many people that I know that don't do that, and my wife and I both try to be active, and because I guess we're trying to fight the old age, but it isn't working.
Let's talk about some of the things that you continue to do, Curtis. Mr. Reeves. My apologies, Your Honor. Take out the garbage.
Yes, sir.
Still do that.
Yes, sir.
Mow the yard.
Yes, sir.
Still do that.
Yes, sir.
Trim the hedges.
Yes, sir.
Still do that.
Yes, sir.
Wash the house.
Once every 7 years or so. Yes, sir.
Pressure wash.
Yes, sir.
Cut limbs in your yard.
Have a lot of oak trees. When the wind blows them out, I pick them up and dispose of them.
And cut them.
Yes, sir. If they're too big to burn, I'll cut them and make them smaller.
When you're doing all of those chores, are you in pain?
Most of the time.
Do you feel bad every day? Do you have pain every day?
If I'm not careful, yes, sir.
Sometimes you have no pain at all.
Sometimes it's not as noticeable. Let's put it that way. You kind of.
Your Honor, I would object to relevancy for 2014.
Yeah, I'm going to sustain it.
Okay. Let's talk about 2013, some of the things that you had difficulties doing. You were on the floor. Difficulties getting up off the floor?
My granddaughter was with us for a while. I tried not to get on the floor because you had to find something to pull up on to get up off the floor. So yes, that was a problem.
Opening a jar of peanut butter.
I lost the strength in my hands quite a few years ago.
Does that mean that you weren't going to the range anymore to shoot?
No, sir. I guess I could explain it like that was an opportunity to get together with my friends and do things that we've always done. So you're willing to put up with the aggravation and the pain to go and have a good day at the range and have lunch with your pals.
I'm going to direct your attention to January the 13th of 2014, Mr. Reeves.
Yes, sir.
What did you decide to do that day or that midday here in Pasco County?
My wife and I had, or maybe my son and I had decided that we wanted to see a movie that was showing, and I spoke with my wife, and she said she'd like to go too. So we researched where it was on at and what time it started.
And what movie was that?
I'm sorry?
What movie was that?
That was a Lone Survivor.
Okay. And so about what time do you think you got to the theater that day?
I think right around 1 o'clock.
And what did you do as you went into the theater?
We were a little early for the show, and our son was going to meet us, and we didn't know exactly when he was coming, so we kind of stood around the lobby for a while when we first got there, waiting for him to get there.
Okay.
Mr. Escobar?
Yes.
I think it would be appropriate to take a short recess before we go any further.
Yes, Your Honor. Thank you.
We've been going about an hour and a I have. So, ladies and gentlemen, we'll take a 10-minute recess. Please remember my instructions during the break, and we'll see you.
All right, this is the point where the judge said, all right, we're getting to the nitty-gritty. Let's take a break, and then we'll get back into it. Andrew Mishlev is watching along with us. He is a criminal defense attorney in Milwaukee, Wisconsin. What do you think, Andrew, the defendant on the stand?
Well, it's a high-risk maneuver that was necessary for him, and so far, so good. I agree with your previous commentator, Imran, that this is something he had to do, and the defense had to go through his history, his training. They had to humanize him, try to get the jury to feel a connection to him, and at the same time, show some authority and polish that we see in seasoned police officers and that people like and respect. So far, that is successful. And now that we're getting to the day in question, this is where the risk really starts.
Does it, yeah, what about the police training? Is there an element of risk there? Because part of training is de-escalation and not killing somebody at a movie theater. Do you expect that to be topic number one, a topic in cross?
I would, especially since Curtis Reeves uses the word de-escalation, Ted, I would expect the prosecutor to cross-examine very hard on that point exactly. We'll see how Mr. Reeves handles it.
Calm, cool, and collected. Does that, do you think, have to change when he's going through and reliving for this jury what happened, even though it was 8 years ago, that moment, and show some emotion? Or is this who he is?
Boy, that's a tough question. I think he's going to have to make the jury believe that his fear was reasonable. The jury is going to have to feel the fear that he felt and feel as though I would have felt that way. So it's a delicate balance between showing real concern for his own safety and yet not seeming like a hothead. He is walking a tightrope here, but he has to do it.
And does he need to be careful about being, well, you know what, let's do this. Let's get a break in now as we approach the top of the hour, and we're gonna rejoin right where we left off. Curtis Reeves just starting to tell the jury what happened on that afternoon when he went to a movie with his wife and ended up taking the life of another individual who was there. Back after this.
Oh, this started out
welcome back to Court TV Live. I'm Ted Rollins. Glad to have you along with us on a busy Thursday here at Court TV. We're watching two big trials play out, and we are on verdict watch in St. Paul, Minnesota for the 3 former officers charged with violating George Floyd's civil rights. The jury there back deliberating. In Louisville, Kentucky, the trial for former officer Brett Hankinson continues today with day 2 of testimony. Hankinson fired 10 shots during a raid that ended in the death of Breonna Taylor. You can stream that trial over on CourtTV.com right now. And of course, it is day 9 of testimony in the movie popcorn murder trial. 79-year-old Curtis Reeves, accused of murdering Chad Oulson in 2014 during an argument over a cell phone in a movie theater. He has been on the stand all morning testifying about his background and now just getting to the day in question where he shot and killed Chad Oulson. Let's go back where we left off.
Mr. Reeves, some housekeeping matters that my colleagues here reminded me. I'm going to,
You may.
I'm going to show you what's been marked as Defense Exhibit Composite AAA, and have you please take a look at that.
Yes, sir.
You recognize that?
Yes, sir, I do.
And what are those?
Those are certificates of training and professional certifications from my time at Busch Gardens.
Your Honor, we would move AAA into evidence. I'll show
State
it.
Reeves previously made objections.
Okay, same ruling. They'll be admitted as 14.
Mr. Reeves, I'm not going to ask you any questions about that. The jury will have the ability to look at those for themselves. Getting back now to the theater, I believe we left off where you had been waiting a bit in the lobby for Matt, you and Mrs. Reeves, is that correct?
That's correct, sir.
And then you indicated that you proceeded to go into the theater after buying some popcorn and a drink, is that correct?
Yes, sir.
Okay. And so when you went into the theater, where did you sit?
We sat on the very last row, almost in the middle of the theater. There's a wall that you, at the very back of the theater, there's a wall. We were right up against that wall.
Was it still pretty early on, meaning that the previews were not playing? You were just there for a period of time?
The lights were up. There may have been something on the screen. We weren't paying much attention. It was probably housekeeping stuff like the concession stand, that sort of stuff.
Okay. And can you tell the ladies and gentlemen of the jury whether Mr. and Mrs. Oulson were likewise seated in front of you and your wife?
Yes, sir.
Okay. How long of time passed during that period of time before the previews started?
I'm going to guess 10 minutes maybe, or I don't know exactly. 10 or 15 minutes because we got there rather early.
Okay. And during those 10 or 15 minutes, did you notice whether Mr. Oulson was using his phone?
Yes, sir, I did.
Okay. And did you, during that time, at any point in time, interrupt his using of the phone and tell him to stop using the phone or anything like that?
Not until after the preview started.
Okay. And so for those 10 or 15 minutes, you and Vivian sat there, discussed whatever you all were discussing, is that correct?
I had texted my son and told him where we were sitting so he could find us, and other than that, just talking, I guess.
Okay. At some point in time, does an announcement come on?
I think right about the end of the advertisement says the turn off your cell phone graphic, I guess you could say, and then they announced to turn off your cell phones if I remember correctly.
Okay. And did the previews then start?
Yes, sir, they did.
Okay. And so the previews start, the announcement has already come on, and were you looking at the previews?
Yes, sir.
And was your wife, Mrs. Reeves, also looking at the previews?
As far as I know.
And why were you looking at the previews?
Well, that's kind of how we decide what shows we're going to see. We kind of look at the trailers
To see what's coming?
to see what's coming, and then we'll decide whether or not we want to come.
Okay. At some point in time while you were viewing those previews, did you notice a light shining in the theater?
Yes, sir, I did. I noticed off to my right, over who turned out to be Mr. Oulson's left shoulder, was a cell phone.
And was that light shining on you?
It was shining in my face. Yeah, I tried to adjust my seat position, but it was still shining in my face.
What did you do at that point?
I waited for a while after they started because I don't know how long. I waited to see if he would put it away, if he was interested in what was on the screen or not, and it never went away.
And so what did you do, realizing that it was not going to be turned off as the announcement had requested of all patrons?
Let's keep our cell phones off, please.
When I realized that it wasn't going to go off and that it was still shining in my face, I leaned over and requested that he turn his phone off. I said, "Would you mind turning your phone off, sir?"
Okay. And so when you're saying leaned over, you were seated in your seat.
Yes, sir.
And tell the ladies and gentlemen what you mean by leaning over.
Well, when you're in the theater like that, I don't know how far apart we were, but I wasn't communicating with anybody but this gentleman. So I would lean over to get a little bit closer to him so that I didn't have to yell at him, and I just asked him if he'd put his phone away.
Okay. At that point in time, were the previews playing?
Yes, sir.
Were the previews loud?
Loud, and the lights had gone down. It was darker, but that's what I remember.
Okay. And so what response did you get from Mr. Oulson when you leaned forward to tell him, that was quietly, you said?
Yes, sir.
To please turn his phone off?
It was saying it loud enough to where I heard it.
And so what did you do at that point?
I sat back in my chair and still thinking that he might put it away.
Did you overhear some additional conversations after that statement was made to you?
I heard him talking because he was talking loudly, and I think he was talking to his wife or maybe to the theater in general because it was loud. And I perceived that his wife had reached over with one of her arms, and my thought was that she was probably trying to get him to quiet down.
Okay. And so what are you doing at this point in time? Are you just seated back?
Yes, sir. I waited to see if he was going to turn his phone off.
Did you attempt to try to hear what was being discussed between Mr. Oulson and his wife?
No, sir. I don't think I did. It was loud. I could hear him talking. I never heard her say anything, and I really just picked up a word every now and then.
Okay. So, how long do you think you waited before you decided to leave the theater?
I think somewhere between right around 3/4 of a minute, I guess, half a minute, 3/4 of a minute. And it was still prominently displayed and still shining in my eyes.
Okay. And so what did you decide to do at that point?
Well, I decided that if I couldn't get him to turn it off, that it was between him and the theater. They're the ones that said you can't use one. It wasn't between him and I. So, I again, being not necessarily gentle, but I just leaned over and I said, "You leave me no alternative other than to notify the management."
And how did he respond to that? And so what did you do at this point?
Well, he was saying some other things that I could pick up a word every now and again. He was being kind of loud and stuff like that. But I didn't pick up any words, so I had a bag of popcorn in my hand. I handed it to my wife, and I started down the aisle towards the end aisle.
Mr. Reeves, why at that point in time didn't you just move your seats?
Well, the guy was just being mouthy. I mean, I've had a career of dealing with people like that. It didn't present a threat to me. I probably didn't think about how it affected my wife, but to me, I saw no threat to it at all.
And so you get up to do what?
I got up to go to down the aisle to the end to go to the manager's office.
Okay, and it was still dark in the theater?
Yes, sir.
Okay. And as you were leaving the theater, did you speak to any of the patrons where you were trying to get by?
Well, yeah, there's not a lot of space in there, and I didn't want to bump this guy's chair, so yeah, I used the wall behind me or behind my wife to kind of steady me as I walked down the aisle, so I didn't bump into his chair or step on anybody else's feet.
Okay. And you proceeded out?
Yes, sir.
Okay. And where did you go?
I went down the stairs, and I went out front, and there was a young man at the where they take the tickets, and I asked him if there was a manager nearby, and he pointed me towards the guy that was sitting in the kiosk out front.
Okay. And so when you get to the individual that was at the kiosk out front, was there somebody else that was speaking to that manager at the time?
Yes, there was a lady standing right around the counter from me. She would have been on my right, and she was conversing with the manager back and forth at that time.
Did you interrupt them at all during that process?
No, sir, I didn't.
Okay. Did you wait for your turn to speak to the manager?
Yes, sir, I waited until he acknowledged me.
And can you tell the ladies and gentlemen of the jury exactly what you told the manager at that moment?
I told him that there was I said I kind of apologized to him and said I feel kind of strange doing this, but I'm a guy complaining on another guy. I said, but I've got a guy sitting in front of me that is using his cell phone, and I asked him politely to put his cell phone away, and I said he used a lot of profanity, and I said I don't feel comfortable talking to this guy again. So could you help me out?
Okay. And what did he say?
He responded that he would take care of it.
Okay. So where did you go then?
I went back in the theater.
And did you go back into your role?
Yes, sir.
Okay. And did you try to get back to your seat in a polite and courteous way?
Yeah, going in and out. I told people, most people don't go out right after the show starts. It's kind of awkward, so I kind of felt awkward leaving at that particular point. But I said things like, sorry, I have to get by, and excuse me, that sort of thing. Yes, sir.
Okay. Were you mad?
No, sir.
When you got up off your seat to go tell the manager, were you mad?
No, sir.
You heard Mrs. Roy come and testify before this jury. When you were leaving the theater, were you grumpy?
No, sir.
Did you tell the manager where you were seated?
Yes, sir, I did.
As you were walking back to your seat, did you get back to your seat?
I got back to my seat, and then I took the popcorn bag from my wife and sat down and got it from her. One or the other, I got it from her.
Okay, and during that time period, did you hear Mr. Oulson making any statements?
Curtis Reeves on the stand talking about the moment where he and Chad Oulson got into a battle over the cell phone of Chad Oulson when the previews were playing. What happened next? We'll find out next. Stay with us.
I'm Vinny Politan. Welcome to
TV Live, Curtis Reeves on the stand telling the jury what happened that day in the movie theater near Tampa, Florida. He has just told the jury that he went to complain to the manager that Chad Oulson had his cell phone out and he asked him to put it away and he used profanities. What happened next? According to Curtis Reeves, let's find out. Let's go back in right where we left off.
Talking to me, I don't know who he was talking to. He was talking, again, kind of loud. And he was saying something about the manager and the theater. I didn't pick up every word. I was standing up, and it was something about the theater and the manager, and he had been kind of staring in my direction, and I don't know. He wasn't talking to me, but he was speaking out loud.
He was staring at your directions as you were walking?
As I came back in, yes, sir. He kind of looked in my direction.
Okay. And was he accusing you of turning him into the manager?
I kind of interpreted it as that, but I didn't hear those exact words. It was, I think he was trying to relay that he was not happy.
Okay, and then what did you do at this point?
I tried to, I think the word is diffuse the situation, so I made a comment to him about if I had known that you had put your phone away, I wouldn't have involved the manager.
Okay. Now, Mr. Reeves, tell the ladies and gentlemen of the jury what happens at this very moment.
As I sit down, he's still talking loudly, and he's facing away from me. I can pick up a word every now and then, but I don't know what he's actually saying. And a movement caught me off on the right side of my eye, and I turned my head to look at him, and almost immediately he had turned and was on his feet, and I had something between me and the theater screen that I saw just a flash of a reflection off of, and then everything went kind of fuzzy.
Did you believe at that point that you had been hit?
Yes, sir, I did.
And where do you think that you were hit at that moment?
I think I was hit on my glasses on the top left side. That was where I felt the impact, I think, and I wasn't sure how it had happened because I didn't think he was that close to me, so it had to be something else.
That's what you thought?
Yes, sir.
This blur that you saw, were you able to describe it?
It was like a flash. It was between me and the screen. It was very close to me. It just didn't compute. I had no idea what it was at that time.
At that moment, did it appear that he was coming into your space?
At that point, I noticed that he was standing up. He was yelling a lot of profanities. There was threats and bits and pieces, because this guy is very volatile and active. He's trying to come over the seats.
Did you try initially to get up?
I was in a seated position, and when I first detected the profanity and stuff, he was trying to come over the seat. He was trying to. I felt like he was trying to either that or get to me, one or the other. It appeared to me I've never been in that kind of a position before, and I realized immediately, and I don't know whether he got onto his seat. I don't know what happened, but when he stood up, I'm sitting down in a completely defenseless position. I'm looking up at this guy, and he looked like a monster standing there. He was mad. He exhibited explosive behavior, both verbally and physically. And I had seen his wife, who had tried to control him when he jumped up, and she had a hold of his arm, and he had turned around. At that point, I was focused on him.
Why at that point were you just focused on him?
He was a threat. He was a threat that was very close to me. And the closer a threat is to you, the less time you have to react to anything that happens. I had tried to get further away from my wife because he was after me, and I had leaned as far as I could to my left, and I had kind of straightened my right leg out towards where my wife was sitting, and I didn't want to again hit his chair. He just appeared to me like he was out of control. That it was like his wife was kind of hanging onto his arm or his shoulder. She was in the peripheral. I saw him. He was reaching for me or trying to come over the seat again. It was at that point I couldn't get up. I was trapped. I couldn't go left or right, and even beyond being seated in front of this guy that's standing up in front of me, I'm leaning to the side, completely defenseless. I could do nothing to defend myself.
At some point, do you decide to pull your weapon?
At some point after he's reached, either trying to come over the seat or tried to hit me, at some point I made a decision that I had no alternative. The guy's, in my opinion, he's completely out of control. He's not settling down, and his wife is trying to hold him back, or appear to be trying to hold him back, or control him. I guess that would be the right word. And I've never been encountered by somebody exhibiting that uncontrolled anger or rage, and all of the perceptors that you could imagine, whether it's verbal, physical, expression. At some point at that time, I had no other choice, and I reached for my pistol.
Now, after reaching from your pistol, do you see some hands coming in your direction?
I'm pretty much zeroed in on him, and I know I made some comments at some point in there as this was happening. It was very quick. In my mind, it was, the event itself was very fast. And I didn't think I had enough time to respond. And at that point, I was concerned that he was so much above me and so full of rage, I guess you could say, that he was going to strike me with all the strength that he had or he could put together. I figured that this was the end of the line for me. I thought that at the very least I'd be seriously injured, if not killed.
Curtis, did you feel at that point in time that you had the capabilities to ward him off with your bare hands?
I was pretty sure I couldn't do that. That was never a question. In the position that I was in, there's no way I could have done that.
You fired a shot from your pistol?
One shot.
What happens after you fire that shot?
As soon as he turns away, then he's no longer a threat. So I lay down the pistol, and then I try to determine how bad I'm hurt. And then I realized that my glasses, the reason that everything is blurry is because my glasses were kind of sideways. I'm going to call it askew. This left piece here was down on my cheek, and my glasses were kind of, I guess you could call it askew. That's when I realized that the reason everything was so blurry was because my glasses had been knocked off.
Well, were they knocked off or were they askew?
Askew.
Okay. Were those the glasses you were wearing?
Yes, sir.
Okay. May I see them?
Yes, sir.
May I approach?
You may.
It's okay if I look at them as well?
Yes.
Thank you.
Curtis, these are the glasses
All right,
that...
we're going to step aside, take a break. The jury's looking at his glasses. Curtis Reeves just explained what happened in his mind. Back with more testimony right after this. Stay with us.
Dexcom G6. I don't.
Reeves told the jury in Florida that he was scared for his life and had never encountered something like this in all of his years in law enforcement when he encountered Chad Oulson in that movie theater. Let's rejoin the testimony right where we left off.
Yes, sir.
And don't be insulted. These are old man glasses that can switch and turn in every direction known to man. I'm not going to break them.
Yes, sir.
Right? I've done this before, right?
Yes, sir.
And these are the glasses that you were wearing that day?
Yes, sir, it is.
Curtis, did you want to shoot Chad Oulson?
I didn't want to shoot anybody. I came to the theater with my family to enjoy a movie, not to be attacked by some guy that's out of control.
The most dangerous of individuals are what? Individuals that are out of control?
Absolutely. Anybody that's not controllable, their rage is so powerful, their thought patterns, in my opinion, are only towards whatever they feel anger towards. They're not influenced by the surrounding area.
Had you ever in your entire life seen anybody act the way Mr. Oulson acted in a movie theater? Do you ever see anybody? Do you ever experience anything like that?
I've never experienced anything like that inside of a theater or anywhere else. That was a complete surprise. It was a shock that somebody would actually do that. And I guess the thing that I couldn't understand, and all this passed through my mind right away, is why is somebody acting like that over such a trivial thing? I still haven't figured that out.
Why were you trying to create distance at some point in time in this situation?
Well, any time that you're involved in any kind of and I'm going back to training and exposure and experience for years, any time that you're going to be involved in something like that, the first thing that you want to do is get away from the individual. You want to, that would diffuse it. If you could get away from them, then whatever is going to happen may not happen. If you can't, then you're like in my case, I had nowhere to go and no way to get there.
How quickly did all this happen?
In my mind, it was the blink of an eye from the time I sat down until it was over.
Once you fired the shot, did you say, "Throw popcorn at me, will you?"
I had no knowledge at all about that popcorn. It must stay, but the deputies asked me that, I think. I never saw the popcorn until I saw it on the floor. I had no idea what had happened to the popcorn.
Did you shoot Mr. Oulson because of popcorn?
I shot Mr. Oulson because I thought he was going to seriously injure me or potentially kill me.
May I approach? Mr. Reeves, I'm going to show you what's been marked as State's Exhibit number 55, and I'm going to show you what's been marked as State's Exhibit number 51, and ask you if you recognize those exhibits.
Yes, sir. These are the photographs that the ID tech from the sheriff's office took, I think, in the theater.
Did you get an opportunity to see yourself in a mirror while you were seated in the front seat of a patrol cruiser?
Yes, sir. The detectives put me in the passenger when they were conducting the interview, and I asked them if I could use their little mirror.
And why did you ask them if you could use their mirror?
After I had, my eye was still bothering me, and I had already...
Which eye was that?
Sir?
Which eye was that?
Left eye.
Okay.
Yes. My eye was still bothering me, and I wanted to see if I could see anything in it.
Okay. And does those pictures fairly and accurately depict what you saw in the mirror?
Yes, sir, it does. Yes, sir.
Okay. And what do you see on the left eye, the corner of your left eye, in the state's exhibits?
Yeah. It appears to me that the left corner of my eye going down across I don't know, this area right here from up here on my top of my eyelid down to this little corner there.
Now, Mr. Reeves, when you put the firearm on your lap, why did you do that?
Because you don't know who else is in the theater. You don't know who else is armed, and I didn't want to be. I wasn't a threat to anybody else. I was only trying to defend myself. I didn't want anybody else to think that I was a threat.
Is that training? Does that come from training and years of training as a law enforcement officer?
Yes, sir, it does.
Okay, and so you put that gun on your left knee?
I put it on my knee. I think it was my left knee.
After you put that gun on your left knee, did someone come and pick up that gun from your left knee?
Yes, sir. As I was adjusting my glasses and examining my face, I didn't see his badge, but a deputy walked up and I heard him say that he was a deputy, and so when I leaned back, I pointed at my pistol. It was on my lap, so he picked it up.
Okay. Now, at that moment, were you able to look down at what was in between your feet?
As I put my glasses back on and the deputy was standing there, I looked down between my feet, and yes, I did. I saw the cell phone between my feet.
Madam Clerk, may I see that cell phone real quick? May I approach, Your Honor?
You may.
Mr. Reeves, I'm going to show you what's been marked as State's Exhibit number 24 and ask you to take a look at the interior of that exhibit and tell me if you recognize that exhibit.
Yes, sir, I think I do. The white spot up here, that kind of caught my eye. I think it was laying on the floor like that. But this is what it looks like, yes, sir.
Is that the phone that was located between your legs?
Yes, sir.
Now, Mr. Reeves, you were arrested right there in seat number 9, correct?
Yes, sir.
Okay, by law enforcement.
Yes, sir.
And you were taken out in handcuffs to a vehicle, is that correct?
Yes, sir.
And then you were interviewed.
Yes, sir.
Okay. And it's my understanding then you were interviewed by Detective Proctor and Detective Koenig, is that correct?
Yes, sir.
Okay. The interview that you had with Detective Proctor and Detective Koenig were recorded, right?
Yes, sir.
And did you answer all of their questions?
Yes, sir, I did.
And did you encourage them to ask you any questions that they needed to ask you there in that interview?
Yes, sir, I did.
And you waived your rights to remain silent
Yes, sir, I
that
did.
day, is that correct?
Yes, sir, I did.
And you told them that you wanted to cooperate?
Yes, sir.
And did you?
Yes, sir.
May I have a moment?
You may.
No further questions.
Thank you. Move to the approach? Yes.
Okay, that's the direct examination of Curtis Reeves. Did he sway the jury? His version of the events that took place at the movie theater the day that he shot and killed Chad Oulson. We're going to step aside, take a break. We're going to check in with our Julia Janae, who was in the courtroom. And we'll talk about what we have witnessed this morning. The jury went on a lunch break at this point, and they will be returning soon. But we'll have much more ahead on Port TV. What a day. Back after this. Welcome back to Court TV Live. It's day 9 of testimony in the movie Popcorn Murder Trial. 79-year-old Curtis Reeves accused of murdering Chad Oulson in 2014 during an argument over a cell phone in a movie theater. He's been on the stand all morning long testifying about what happened on that day. The jury has taken an early lunch break. They'll be returning shortly, and we'll get the cross-examination of Curtis Reeves. How did he do on direct examination? Well, Court TV legal correspondent Julia Janae has been covering this trial. She was in the courtroom and joins us now live outside the Pasco County Courthouse. Well, whew, man, well, we've been waiting and waiting for this. Here it happened. Tell us about the courtroom, set it up, and what reactions did you notice from the jury, from the wives, etc.?
Ted, what command Curtis Reeves has of a courtroom, his very presence on the stand today, that's really what struck me. We imagine that that is how he would be when he answered the questions from his attorney, just with his background, but they focused on those 3 areas today, and I thought that kept it very organized for this jury, starting with his law enforcement experience, then talking about his medical condition, the things that he has issues with, and then getting to this actual incident, and he laid it out play by play, and then they ended things and went to lunch. First, talking about this jury, you can tell that they understand the importance of every word that Curtis Reeves is saying. There was a juror, male juror, who seemed to be on the edge of his seat while Curtis Reeves was talking. Another juror writing a lot of notes, even in the beginning with the law enforcement training that he was talking about. And this jury, thinking about their backgrounds and the things that we know about them from jury selection, we have one who's a competitive shooter. So that training likely resonated a lot with that person. There's also someone who is former Air Force. So talking about, and Curtis Reeves' testimony talking about being over different people, working with his team, all of that time, not only being in law enforcement, having arrest powers, but then transitioning to Busch Gardens and being that security director, all of that seeming to be actually very important to the jury. I also was paying attention to how he was going to be coming up on the stand, because he did talk a lot about that medical condition. Was he going to be sitting there when the jury came in? But here's a look at him going to the stand. He did walk up with his cane. His attorney did acknowledge in front of the jury that this is not what he had at the time of the incident, but I think the optics of that really important, Ted.
Yeah, he's following through with the visual for the jury that he is an elderly individual who might be a little bit more scared than someone else in this situation. Nicole Oulson, we have seen some shots of her in the gallery through this. At one point, she seemed to be shaking her head. What have you noticed from her?
Noticed that she had great composure through most of this testimony. She did not stop looking at Curtis Reeves while he was talking. She seemed to just keep her lips pursed together, listening to what he had to say. But there was a moment when I noticed that she was shaking her head, making some clear, overt reactions to what he was saying, a word that he used to describe her late husband, Chad Oulson. Take a listen.
At that moment, did it appear that he was coming into your space?
At that point, I noticed that he was standing up. He was yelling a lot of profanities. There was threats and who the do you think you are? I was texting my daughter. Seemed to be his primary vocabulary at that point. Who the do you think you are? Get the I'm going to you up or something. That's not exact, because I'm picking up bits and pieces, because this guy is very volatile and active. He's trying to come over the seats.
Did you try initially to get up?
I was in a seated position, and when I first detected the profanity and stuff, he was trying to come over the seat. He was trying to. I felt like he was trying to either that or get to me, one or the other. It appeared to me that I mean I've never been in that kind of a position before, and I realized immediately, and I don't know whether he got onto his seat. I don't know what happened, but when he stood up, I'm sitting down in a completely defenseless position. I'm looking up at this guy, and he looked like a monster standing there.
That word monster clearly struck a chord with Nicole Oulson, having to hear that as she sits there in the gallery. Ted, yesterday this jury was shown an image through the scene reconstructionist of a mannequin that expert used to try and explain where different people were inside of the theater and to show how backlighting can change how someone looks if that movie screen is behind them. And I remember thinking how ominous this mannequin looked, even though it was not supposed to represent Chad Oulson in the eyes of the jury. The expert was not supposed to say that's what he looked like. But I'm just imagining the imagery that this gives the jury, seeing that mannequin in this dark, shrouded-looking image yesterday, and then hearing this word, a monster, from the defendant from the stand. Really important for this defense to get that in front of them in this way.
Of course, cross and redirect will eat up most of today. Where are we? It's day 9 today. What has the judge told the jury in terms of expectations?
Ted, they're actually very confident that on Friday things could wrap up, even possibly the deliberations or deliberations will at least start on Friday, which there could be some more witnesses after Curtis Reeves, but they expect this jury is going to get instructed and then we'll get handed this case by tomorrow afternoon. So that timing, it's wrapping up shortly. We could have a verdict tomorrow, depending on how long this jury takes.
All right, Julie Jane, we'll let you get back into the courtroom. The jury on an early lunch today. They're expected to be back live very soon. Andrew Michel has been watching along. Got to get your take. Direct, how did it go overall, and what are you looking for in cross here, Andrew?
I thought the direct went well for Curtis Reeves. I was interested in Julia's comment because she's in the courtroom and she could feel the emotion. I did not feel that come through from Curtis Reeves when he was describing the shooting itself. I found it was interesting that he answered a leading question from his lawyer, so you shot. And he said, and his answer was one shot. That was very cautious. The lawyer did not allow Mr. Reeves to describe shooting, pulling the trigger, because I think that would have been risky. It was an effective direct examination. I think he did well. We'll see how he holds up under cross-examination.
Yeah, it will be fascinating. Andrew, thank you for your expertise. Appreciate it. Watching along with us. We're going to step aside, take a break as we approach the top of the hour. When we come back, we'll hear that cross-examination of Curtis Reeves, plus check in with Chanley Painter in St. Paul. Verdict watch in the case against the 3 officers accused of violating George Floyd's civil rights. That and more next. Julie Grant will be here.
for a plan with extra benefits. Call 800-693-5145. 800-693-5145.
Good Thursday afternoon to you, and thank you for being with us here at Court TV Live. I'm your midday host, Julie Grant. Boy, oh boy, it is a busy day here as we're following developments in several major cases happening all across the country, beginning this afternoon with some breaking news out of Florida in the movie popcorn murder trial. Defendant Curtis Reeves took the stand today testifying in his own defense, and he's not done. He's just done with a direct examination so far. He is accused of the shooting death of Chad Oulson following an argument inside of a movie theater back in 2014 over Oulson's use of a cell phone. And as with most witnesses the defense team has called, Reeves spent a great deal of time talking about his police and his military background and his health conditions. So court went on an early lunch break today around 11 o'clock, just as Curtis Reeves was talking about what happened that day in the movie theater. So we were playing every bit of what happened earlier for you. You've seen it all. As soon as court resumes, we're going to go back in live, and it's going to be time for his cross-examination. We also want to get you caught up on some other trials we are covering for you out of both Minnesota and Kentucky. We, of course, have our crews in Minneapolis, Minnesota. Chanley Painter is there. She's covering the verdict watch for the 3 Minnesota police officers who are accused of violating George Floyd's civil rights. We're also in Kentucky, where today is day number 2 of the case of former police officer Brett Hankinson. He's accused of wanton endangerment, not accused in Breonna Taylor's death. But the wanton endangerment charges were part of that raid effort for bullets that he fired that night after her boyfriend returned fire that went into a neighboring apartment. So to be clear, he is in no way accused of Breonna Taylor's death. This is just for bullets fired into another apartment where nobody was injured. So we want to bring in now Court TV crime and justice reporter Joy Lim-Nakrin. She's standing by at the courthouse to give us the very latest on what we saw this morning. Joy, good afternoon.
Good afternoon, Julie. So this morning we saw Sergeant Jason Vance, formerly with the Louisville Metro Police, continue his testimony, which he began late this afternoon. And Sergeant Vance is very important to the state's case here because he interviewed all of the officers involved in that botched raid, which was focusing on Breonna Taylor's apartment. And this morning, via his testimony, the state introduced the interrogation video or interview video of Hankinson, Brett Hankinson, the defendant in this case. So again, this is Sergeant Vance interviewing Brett Hankinson. Let's play a clip.
Did you discover any guns other than the 9mm under the bed in the south bedroom?
No.
And you searched every inch of that apartment?
The legal authority that allowed the public integrity unit to search that apartment would have encompassed any projectiles, which a projectile can be anywhere. So the scope of our search was limitless. So what that meant is we could search anywhere in that apartment legally.
Did you find any evidence of narcotics?
No, and there was no narcotics listed on the property section of our legal authority. So the procedure on that would have been as we would have come in contact with narcotics, we would have written an additional legal authority to seize that.
So, Julie, you hear in the testimony of Sergeant Vance there, that's where he's actually talking about the search of Breonna Taylor's apartment and what was discovered there, actually no narcotics. And remember, that was the initial intent behind this raid, this botched raid. But again, it is very important, the testimony of Sergeant Vance to the state's case, because he did interview Brett Hankinson, the defendant on this matter. And as you mentioned, even though this particular case really focuses on Cody Etherton's home and the effect on the neighbors, really Breonna Taylor's name has been said multiple times throughout this trial, and the circumstances surrounding her death have been certainly something that the jury has gotten to hear quite a bit about.
Right, Joy, I wanted to ask you about that, please. And you made this point very well yesterday when you were interviewing Breonna Taylor's sister about how we know the case legally is not about her. She is not one of the listed victims on this indictment that Brett Hankinson is facing. But yet we know that she is very much what this case has been about. Her name is talked about. The attorneys keep mentioning it. Tell us kind of how her name's being brought up throughout the trial and throughout the story that we're hearing.
So really, you know, the reason why we are here in some senses, even the defense admits, is because of Breonna Taylor, right? I mean, the reason the officers were out there at this apartment complex on the day in question is because they intended to conduct a raid on Breonna Taylor's residence. Their target there was Jamarcus Glover, who was her ex-boyfriend. But we did see in court that, you know, among the evidence that they found at Breonna Taylor's apartment was correspondence between herself and Jamarcus Glover, some of Jamarcus Glover's mail, of course. And, you know, central to the state's case is the fact that while other officers had been focused on the target apartment, in this case, Breonna Taylor's apartment, and their gunfire was focused in and around that apartment, the shell casings were found in and around that apartment, that Brett Hankison's gunfire was focused elsewhere and, in fact, entered the apartment of the neighbors. And, in fact, all 10 of his shell casings, according to the state, were discovered in the parking lot. So obviously a completely different direction. That's something that the defense doesn't dispute. They're not disputing kind of where he was shooting and the trajectory of the bullets and where those bullets ended up, but rather they're saying that essentially there was so much chaos and confusion at the time that their client did act in a reasonable and justifiable manner, Julie.
Sure. Julie, remind us again, if you would, please, the makeup of the jury there that's hearing the case.
Yeah, so, you know, it is not an incredibly diverse jury, but there is some diversity present. There is a South Asian woman who is a member of the panel out of the 15 jurors. There is one Hispanic or Latina woman. There are 3 white women, 1 black man, 1 East Asian man, and 8 white men on the panel. Of course, with those 15 jurors, 3 are alternates. And, you know, again, even though this particular case is about wanton endangerment concerning Cody Etherton and his pregnant partner and her child, for many people there is an important context here involving Breonna Taylor and social justice, of course.
Right. Joy, what can we expect later today as the trial continues progressing, please?
Yeah, so we do expect to hear from more law enforcement experts. In fact, the state said from the outset that most of their witnesses will be members of law enforcement because, of course, this raid involves so many law enforcement officers. And then, of course, the investigation of it involved fellow law enforcement officers. Now, the jury was expected to tour the scene today, but with some inclement weather in the forecast, that was postponed to tomorrow. That jurors will actually get to see the apartment complex where all of this transpired.
Joy Limnakron reporting there for us in Kentucky. Thank you so much for that update. We'll look forward to talking with you a little later in the program, Joy. Right now, I want to bring in my guest on the show today. We have a special guest. His area of expertise is in use of force. So really, all of these cases, we happen to be having our eyes on our cases that he can lend his expertise to. We want to welcome in Dave Wright. He's served for many years on the Pittsburgh Police Department. He's a qualified expert in state and federal court. He travels all around the country training police how to properly use force, different types of hands-on instruction, conducted energy weapons. I could go on and on, Dave. First, let's talk about the Brett Hankison case in Kentucky. This detective is accused of 3 low-level felony offenses, wanton endangerment. We heard Joy Limnakron telling us that, you know, his brass fell in the parking lot and the bullets went through, you know, some of them at least went through the wall of a neighboring apartment. Thank goodness nobody was hurt. But when you're looking at the situation from an officer's standpoint, what should we be mindful of, please?
When an officer deploys his firearm, his or her firearm, they're going to do so because they're in fear of their life. That's how they're trained. And I might note, their training is to stop a threat. It's not to kill somebody. It's not to maim somebody. So in regards to his defense, he's going to claim that he acted within the scope of law, within the scopes of his law enforcement powers, and that he was doing so in defense of his life or someone else's. And certainly when you're serving a warrant, there should be some pre-planning involved. There should be, you try to limit the amount of potential for surprises. And So the officer's going to have to clearly illustrate why he was using deadly force, and that's going to be the basis of his defense.
Yeah, and we're going to hear so much more from this case as it continues. We're only in day number 2. Dave Wright, so glad you're with us. We're going to squeeze in a break. When we come back, we hope to see the resumption of the case in Florida, the movie popcorn murder trial. The defendant is on the stand. We're going to see the cross when the jury comes back.
All the crimes, all the
After reaching from your pistol, do you see some hands coming in your direction?
I pretty much zeroed in on him, and I know I made some comments at some point in there as this was happening. It was very quick, in my mind, it was, the event itself was very fast, and I didn't think I had enough time to respond, and at that point, I was concerned that he was so much above me and so full of rage, I guess you could say, that he was going to strike me with all the strength that he had or he could put together. I figured that this was the end of the line for me. I thought that at the very least I'd be seriously injured, if not killed.
That was Curtis Reeves sharing how he felt on the day in question. Was it self-defense, as he says, or was it murder, as the state of Florida says? Let's go back into the courtroom now together live. It is time for the cross-examination.
To abide by my instructions during the recess? Yeah. All right, then we will get started again. Mr. Rosenwasser?
Yes, thank you, Your Honor.
Mr. Reeves, you're still under oath.
Good afternoon. Good afternoon. I have copies of the post-Miranda statement as well as a hearing transcript for you. So if any time you think it's necessary for you to review those documents, let me know, okay?
Yes, sir.
All right. I have a couple preliminary questions for you. When you have your glasses on, you had 20/20 vision?
Yes, sir.
Okay, and back January 13th of 2014, when you had your glasses on, you had 20/20 vision, correct?
Yes.
All right, and you indicated that the glasses you're wearing today are the same glasses you were wearing on January 13th of 2014?
That's correct.
All right, and I think we looked at it. May I approach the witness, please?
You may.
Here's what I'd like to do, if it's okay, is publish his glasses to the members of the jury.
Okay.
Maybe I'll have the bailiff do it. All right, just a few preliminary questions. All right, your testimony is that you intentionally shot Chad Oulson, correct?
Yes, sir.
This wasn't an accidental shooting. You intentionally pulled the trigger, correct?
That's correct.
Did you kill him out of rage?
No, sir, I did not.
How about blind fury?
I'm sorry?
Blind fury. Did you kill him out of blind fury?
No, sir, I killed him out of fear.
Okay. You didn't just snap and kill him?
No, sir.
And you had brought your firearm to the theater in a holster that's been admitted into evidence, correct?
Yes, sir.
And that was in your right pocket?
Yes, sir.
Now, at the time of the shooting, you had been retired for 20 years, correct?
Yes, sir.
And you testified that back when you went to the academy, that was what, back in the late 60s?
The recruit academy, yes, sir.
Okay.
Probably 66.
Okay. And you had about 320 hours of training at that time to become a law enforcement officer?
I think, yeah, yes, sir.
Okay. Are you aware that there's today 770 hours?
I have no idea, sir.
You don't know? Okay.
No, sir.
Would it surprise you to learn that?
Everything changes. No, sir, it wouldn't.
In other words, the academy is over 2 times longer now than it was back then.
Okay.
Now, you testified about punches and things like that. You recall that testimony?
Punches?
Right. You know, you've seen, what punches. You've investigated cases where people have punched people, right?
Oh, yes, sir. Yes, sir.
Okay. And when you intentionally touch or strike someone against their will, that's the crime of battery, right?
Yes, sir.
All right. That's a misdemeanor?
Yes, sir.
All right. And the mere fact that someone touches you, you can't shoot and kill them, correct?
That's correct.
All right. And even if someone just throws something on you, no matter what it is, keys, a pad, you can't kill someone for doing that, correct?
I think it would depend on what it is that you throw on them.
I understand, and I'm going to make it very specific. Let's say someone tossed a cup of water on you.
No.
You couldn't kill them, correct?
No, sir.
Anything that's not a deadly weapon, you can't kill them.
I'm gonna object at this point in time. It's calling no predicate for a legal opinion. Because you're talking now about a legal opinion.
Didn't he put forth all his training experience?
Yeah, approach.
I think more importantly, where is the prosecutor trying to go with this line of questioning? He started the cross by showing the jury the defendant's glasses. While they're at this sidebar, we're going to squeeze in a break. I promise you won't miss a moment of this cross-examination. We thank you for watching Court TV Live.
We've all been there.
for staying with us. We want to go back into the courtroom together in Dade City, Florida. The defendant, Captain Curtis Reeves, is on the stand, and he was just being questioned on cross-examination by the state about some of the types of cases you could run into, like assault and battery cases and deadly weapon use. And one of the last questions drew an objection from Reeves' attorney, saying that what the question is doing is calling for a legal opinion, which can't happen. He's not a lawyer, and it was kind of irrelevant. Let's just see where the prosecutor is going. Sidebar's broken up now. Let's watch.
Go ahead.
Based on the extensive conversation that was had on direct examination regarding your background, isn't it true that if an object, a non-deadly object, is thrown at you, thrown at anybody, you can't kill that person for throwing that object at them, correct?
If it's, that's kind of a hard question to answer because.
I'm going to give you an example. I'll give you an example. Okay? I'll give you an example. Someone throws a plastic water bottle at another person. It hits that person, falls to the ground. You can't kill that person for doing that, correct? That's the fact pattern. That's all it is. That's all I'm asking you.
That would, under those conditions, no, sir.
Now, you were talking about all the different units that you've been assigned to at the Tampa Police Department, correct?
Yes, sir.
All right. Now, if you came across somebody that had a firearm, for example, you could hold them at gunpoint, correct?
As a civilian?
No.
As a law enforcement officer?
Correct.
You would, if you came up, you had
same objections concerning his position as a police officer, where he wasn't a police officer at the time of this incident.
Okay, I'll rephrase it. Okay.
Thank you.
As a civilian, isn't it true that you could pull out a firearm and just point it at somebody in self-defense?
In self-defense?
Correct.
Yes, sir.
And you were indicating that you had been trained in de-escalation tactics, correct?
Yes, sir.
And de-escalation tactics are when you can reduce the intensity of a conflict, right?
Yes, sir.
And a way that you could do that would be to loudly say something, use words, correct?
I think it would depend on circumstances.
I understand. I'm just asking you of all the different ways, right? So one of the ways that you could do that is you could use words.
Yes.
Okay. Another way you could do it, as we indicated before, is that if you had a firearm, you could simply point it at somebody.
I don't think that's a good idea. If you point a firearm at someone, you have no idea what their capabilities are. It could be theirs, but they could take it away from you very quickly.
Okay, but at a distance they couldn't do that.
Not at a distance.
Okay, so you could use words, you could point a gun at them, you could also do a combination of both, correct?
Are you talking about as a civilian or as a law enforcement officer?
Well, you were talking about the de-escalation tactics that you were trained in, so that's what I'm talking to. I'm talking about your de-escalation tactics. I mean, you testify that you're trained in all this, correct?
Yes.
Okay, so you could really utilize that at any time, right? That's part of your training.
As a law enforcement officer, yes, sir.
Okay, are you saying that those tools that you learned as a law enforcement officer, you would just abandon them and not use them in the real world? Meaning de-escalation tactics?
I don't think I would point a gun at anybody being a civilian.
Okay, what I'm asking you is this. You've learned in all the training that you can de-escalate a situation by using words, right?
Yes, that's correct.
All right. And you can also de-escalate a situation, if necessary, to raise a gun without firing it.
Yes, I suppose it may not be a good idea if you're not a law enforcement officer.
Okay, and I understand you're not going to give me that. Now, in the past, when someone's had a weapon, you've held them at gunpoint and told them to drop their weapon, correct?
Yes, sir.
You give them every opportunity before you would fire a shot, correct?
Absolutely.
Because that would be a last resort, correct?
Correct.
And I think you indicated that at Busch Gardens you are also trained in de-escalation tactics, correct?
Yes, sir.
Okay. And at Busch Gardens you're dealing with other civilians, correct? Just people who are at a park.
Yes, sir.
And you weren't law enforcement at Busch Gardens, you were security for Busch Gardens.
Correct.
Okay. So you were using non-law enforcement de-escalation tactics at Busch Gardens with just regular citizens who were at the park.
I think their de-escalation is kind of universal.
Right, and that's my point. That's kind of what I'm getting at with you.
Right.
Is that you can use these universal de-escalation tactics to calm things down, especially in a movie theater.
Correct.
Now, you indicated that you were on several different units at the Tampa Police Department, correct?
Yes, sir.
You indicated that you were on patrol,
Correct.
went to a surveillance unit, fugitive warrants, robbery, homicide, and SWAT, correct?
Yes, sir.
Now, would you agree with me those are kind of adrenaline-filled units?
Yes.
You know, and obviously by participating in these units, you kind of like the, for the lack of a better word, the dangerousness component of it. You like to be involved in that type of activity, correct?
I would never say that.
Okay. Well, you didn't shy away from those assignments. You volunteered to go into those positions.
That's correct.
All right. You actually gravitated towards those positions. I mean, every one of those would be a position that entails that an angle, so to speak, of danger.
I think the opportunities were there. I didn't consciously gravitate towards them.
Okay, well, when they opened up, did anybody force you to go into those positions?
No, sir.
Okay, you volunteered to go into those positions.
Yes, sir.
And also, when the positions in the command opened up, you went to apply for those and eventually ended up in a position of command at the department, correct?
Yes, sir.
So you would gravitate towards positions where you would be in control.
I gravitate to positions to make more money.
Okay. But it's also, you were able to control people, correct?
That came with the promotion, yes, sir.
Now, there was a certificate that you had about firearms instruction. If you are firing from the hip, what do you do with the other hand? How do you prevent yourself from shooting yourself?
The training that we used to train is that you kind of put your left hand out in front of you. You kind of hang it out there to balance out your body.
Okay, so you put it out in front of the firearm?
No, you put it out kind of to your side. And when I don't think it's called hip shooting. I think what it's called is instinctive, or I think I've heard index shooting, I think it is. You try to maintain a body positive position, which means you stay perpendicular to the target, and you kind of put your left hand a little out in front of you so that you're kind of balanced when you come out with the firearm.
Okay, and when you're sitting, isn't it true that you would take the other hand? So, for example, you shot with your right hand in this case, correct?
Correct.
And so when you're in a seated position, so you don't shoot yourself, you took your left hand and you placed it close to your body, correct?
No, I've never trained to do that.
Okay, but that would be a way that you would avoid shooting yourself if you instinctively took your left hand and brought it across your body.
Yeah, but I've never done that. Never.
You've never done that before?
I've never trained that way. I've never, no, sir.
Did you do that in this case?
No, sir.
You didn't take your left hand and put it close to your chest?
Not intentionally.
Well, I'm asking you if you did.
I don't have any idea. I think I had, if I'm not mistaken, a bag of popcorn.
Okay, so just to be clear, when you fired the shot, you didn't take your left hand and put it close to your body to avoid shooting your own left hand?
No, sir.
Okay.
Not intentionally.
Now, you indicated that you had a license, correct? And that was an HR 218 license?
Yes, sir.
All right. And you got that in February of 2013?
Yes, sir, I think so.
Okay. And in order to qualify for that license, you have to shoot a 40-round course, correct?
Yes, sir, I think so.
Okay. And you qualified on both the pistol and revolver, correct?
Yes, I did.
So that would be 80 rounds that you had to shoot then, correct?
Yes, sir.
All right. And again, that was in February of 2013.
Right.
When you qualified with the pistol, you had a magazine, obviously.
Yes.
And how many rounds would fit in that magazine?
I don't remember.
Okay. And in order to load the magazine, obviously you have to press the bullets in. This is going to sound silly, but press the bullets into the magazine, correct?
Well, you pull down with the magazine spring, and you just drop the rounds in the top of the mag.
Okay, and you just have to keep the pressure on the spring each and every time for each and every bullet, right?
You just hold it down and put them all in at once.
And each time you load one, you have to push a bullet in, so there's a little bit more resistance each time, just a little bit.
No, you hold the spring down, and you put them all in at once. You just drop them in one at a time. You only depress the spring once.
And for a revolver, there's 6 bullets in the revolver?
I don't remember if it was a 6-shot or an 8-shot.
Nevertheless, there's 80 different rounds that you had to load during this course, correct?
There's directions on how many rounds to load, yes, sir.
Obviously, you didn't have any difficulty doing that because you were able to get your license.
Correct.
Now, you were obviously present when your daughter Jennifer Shaw testified, correct?
Yes, sir.
All right. And she was talking about how you ride your bicycle. I think it was a road bike and a mountain bike several times a week in 2013.
Correct.
Right?
Yes,
okay.
sir.
And apparently you need coordination for that, right?
Yes, sir.
Okay. I mean, so when you're testifying about the balance difficulties that you've been experiencing for years, you were okay to ride the bike?
Correct.
And you would ride the bike on trails?
No.
No?
On paved surface, I'm sorry. It's a Withlacoochee Trail.
Okay.
But it's paved.
All right. And when you were to go riding, you'd have to pick the bike up, you'd have to put it on the car, drive over to wherever you were using the trail, take the bike off, right?
Correct.
And you heard her testify that on 5 to 6 occasions, the two of you would go to shoot sporting clays, right?
Correct.
And we heard everything that she described about how that works, how you have to load the shotgun, unload it, and everything that she indicated obviously is correct, right?
I think you load your rounds by dropping them in the ejection port rather than pushing them in the bottom. Yes, sir. That was the only difference.
All right. And you were able to track the target as it went across. Now, let me ask you this. Wouldn't it be a good idea to do that if you're experiencing balance problems, right?
I never had a balance problem handling a weapon.
Okay. And you could obviously walk the course. You chose not to take the golf cart, but you walked it instead.
Correct.
She described the kayaking, walking around the neighborhood, pulling the wagon, archery in the backyard, all the yard work covered during direct examination as well, correct?
Correct.
Let's talk about the movie theater. Lighting-wise, the lighting was obviously good enough for you to find your seat, correct?
The lights were on when we came in.
Okay. But at some point in time, you did leave to go talk to the manager.
Yes, sir.
All right, and that was during the previews.
Yes, sir.
All right. And the lighting was good enough for you to leave and come back without any difficulty.
The majority of the lighting was coming from the screen, from the shows.
Okay. But what I'm asking you is this, is when there was enough light for you to leave your seat, go to the manager, and come back.
Correct.
You could see fine.
Yes, sir.
And when you left to go to the manager, you didn't have any concern about your wife, correct? Obviously, you left her by herself.
That's correct.
All right. And there wasn't any issue with Chad Oulson at the time that you left?
At that point, he was just being mouthy. He had presented no threat at all to me or anybody else.
The lighting conditions at that time were safe enough, so to speak, that you were able to, and you felt comfortable leaning forward and telling Chad to turn his cell phone off.
Yes, okay.
And at that point that you leaned over to Chad, there wasn't any safety concern at that point, correct?
I don't know what you mean from
the
him?
first time when you leaned in. You didn't have any safety concern when you first leaned in to tell Chad to turn his phone off, correct?
You mean for me or?
For you.
No, sir, I didn't.
Okay. And the reason that you were leaning in was because you're saying that he had his cell phone on, right? And by on, just it was illuminated.
It was shining in my face, yes, sir.
Okay. So he was holding it out in front of him, and it was shining in your face, and that was bothering you?
Yes, sir.
Now, if you wanted to at that point, I guess you could have gone up and spoken to the manager at that point, correct?
It wasn't a big enough problem at that point.
Okay. But what I'm asking you is if you saw that, if you felt as though that you were in a vulnerable position, meaning, we heard from Dr. Cohen that maybe your perception of yourself would be that you felt vulnerable. If you wanted to at that point, you could have just gone right to the manager and not had any contact with Mr. Oulson, right?
That wouldn't make sense. I would think that you just ask somebody and they would normally put it away.
Okay, but what I'm asking you is you had the option. If you wanted to, you could have just got up at that point and gone to the manager.
I suppose, yes, sir.
Now, at this time in the theater on January 13th of 2014, you were 6'2", about 270 pounds?
Thereabouts, yes, sir.
And you had just returned from a week-long hunting trip, correct?
I think it was about 5 days.
Okay. And obviously, you were fine to sit in a car for a long trip to go up to North Florida.
We stopped for gas and some.
Okay, just normal things like that, correct?
Yeah, I don't recollect.
All right. And Matthew testified that when you would get out to go hunting, you'd walk 100 yards to go to the hunting spot, correct?
Thereabouts, yes, sir.
And during that particular trip, you climbed up 10 feet in the tree stand, correct?
Yes.
Okay. And that's where you had to bring the bow and arrow up, right? And you hunted from that particular spot, right?
Correct.
All right. Now, you'd agree with me that someone that perceived themselves as vulnerable wouldn't climb up 10 feet into a tree and hunt, correct?
I think that I know what my capabilities are, and I felt comfortable doing that.
Okay. So you weren't concerned about you testified about all these issues that you found about. You weren't concerned about your shoulder or your back or these discs. I mean, it was fine enough for you. You felt comfortable enough at that point to go 10 feet up into a tree and hunt.
It's very easy to do, and you have a safety belt on. Not much can happen.
So on that particular day, you go to the theater, And you drove, correct?
Yes, sir.
Okay, obviously you felt good enough to drive, you felt good enough to park a distance away from the front of the theater and walk to the theater, right?
We parked the closest parking spot that was not handicapped.
Okay, but still quite a distance away.
I don't recollect.
You went into the theater, you were waiting for your son, texting on your phone, correct?
Yes, sir, I did.
No difficulties doing that. Now, when you chose the seats that you were going to sit in, you chose the very back row, correct?
Yes, correct.
All right. And you chose the middle seats, correct?
It was close to the middle, yes, sir.
All right. And you didn't have any concern for your health or stability or things like that, knowing you had to walk all the way to the back, all the way over to the middle, correct?
I had a hand railing going up the stairs, and then I used the wall to go across the back, but no, I didn't have any concerns.
Okay. And you know you had to go across people, obviously, if you're sitting in the middle.
I don't think there was anybody there when we came in.
Well, right, but if you're sitting in the middle of the theater, you know at some point people are going to be on either side of you.
That's correct.
All right, so you sit down. Mr. Oulson is in front of your wife, correct?
Yes, sir.
All right. And he was always a row down and to your right, correct?
Yes, sir. He was one row down in
and
front of my
one seat
wife.
to the right.
Yeah,
Okay,
correct.
so during this entire event?
No, sir.
So was he off to the right of you?
His seat was off to the right of me, and when he jumped up, yes, sir.
All right, let's talk about exactly what happened. So you lean forward the first time and you tell him to turn his phone off. Or you asked him?
I asked him to turn his phone off.
Okay, and that's your testimony is that you asked him to turn the phone off.
I asked him to turn his phone off.
All right. And that's when you leaned close up to his face, correct?
I was not close up to his face.
Okay. Well, the video would be the best way to determine that, correct?
That's correct.
And at this time, you had a loaded firearm in your right pocket, correct?
That's correct.
And you indicate that at the time that you leaned forward, Mr. Oulson cursed back at you.
Yes, sir.
So at this point in time, based on your testimony, you know at that moment that this is someone that you probably shouldn't re-engage with.
That's why I went to the manager.
Okay. Now, even though, according to you, Chad Oulson cursed at you and told you that he didn't want to have any contact with you, despite that...
He did not tell me that he did not want to have contact with me.
Okay, well, basically, you're indicating that his statement was one that let you know he did not want to have contact with you.
It let me know that he wasn't going to, he had no intentions of putting his phone away.
Okay, but if you're, I think their way of saying that they don't want to have any contact with you?
I think it's up for interpretation. It was not expected, and it didn't sound particularly violent. It just sounds like somebody mouthing off.
Okay, well, the way that you made it sound was that it was something that was fairly violent because that's what raised your concern level.
I was not concerned at that point.
Okay, so are you saying that when someone says to you, get the
when they're, I suppose that you could reach that conclusion. My conclusion was it was just a guy being mouthy.
Okay, but he actually told you to get out of his face.
First of all, I wasn't in his face, and he was facing the other direction.
Okay, but it doesn't matter which way he was facing. He basically told you to get out of his face. He's telling you he doesn't want to have any contact with you.
And I didn't.
Now, you then get up and you go to the manager, correct?
No, sir.
Okay, because what happens is you first lean in and you tell him to turn his phone off, and that's when he replies to you.
I asked him to turn his phone off. I did not tell him to turn his phone off.
And he responds the way that he did, that we just discussed.
Correct.
All right, so then you waited another 30 seconds, right?
To see if he had put his phone away.
Okay.
Yes, sir.
And engage him again.
I told him he left me no alternative than to go to the management.
That's right. But you did not have to lean forward and say that to him. You could have, as a form of de-escalation, gotten up and just gone out and got the manager at that point.
I think the whole contact that I had with him was an attempt at de-escalation.
Okay.
To that.
Okay, but instead of just getting up and going to the manager, you took it upon yourself to lean in again and reinitiate contact with him.
Yes, sir. I think we've had that. We talked about that.
Now, at this point in time, you could have moved, correct? I'm not saying you were under an obligation to do so, but if you wanted to de-escalate it, and if you felt as though you were a vulnerable person, you could have moved like your wife wanted to.
Correct.
And your wife actually mentioned it to you, but you decided that you weren't going to move.
Yes.
And you heard your wife when she said that, correct?
I believe so, yes, sir.
Do you need to refresh your memory on anything?
No, sir.
All right, so you did hear your wife and you told her that you weren't moving.
I didn't tell her anything.
Hitting pause right here. You're not going to miss a moment of this as we near the top of the hour. We have to get a break in, but before we do that, we want to bring in for some analysis our guest on the program today. He's standing by in Knoxville, Tennessee. You've seen him try a case before here on Court TV. Criminal defense attorney Greg Isaacs. Greg, good to see you. Tell me, if you were defense counsel on this one and watching your client on cross, what would you think?
Well, good to be here, Julie. The mens rea of your client is typically your best friend in a homicide case because, there's no dispute that Curtis Reeves pulled the trigger on his gun. There's no dispute that Curtis Oulson died. But what you want to do is establish what was in your client's mind at the time. And the defense wants to make it as compact as it can be. Basically, that the fight or flight of Curtis Reeves kicked in, that moment when he came nearly over the theater seating, that Curtis Reeves was in imminent fear of death or serious bodily injury. He's coming across much better than he did in the 2017 Stand Your Ground hearing, where he was a little stoic, very cop-like, unemotional. But, as I sit here and I look at this, sometimes you don't anticipate what the other side is going to do. And in direct, the defense made a issue of Curtis Reeves' glasses. And on cross, the very first thing that prosecutor did was take control, ask and require Curtis Reeves to take his glasses off. So one, he assumes control. Your client is vulnerable on the stand. But the image to that jury is there was not a smack with a cell phone. There was not a punch in the face because he is wearing the very same glasses he wore 8 years ago. So I think that may have been an unanticipated mistake by the defense. The other thing that struck me as very odd is allowing Curtis Reeves to testify to hypotheticals. Could you use deadly force if someone threw water or a bottle? And, Julie, one, it's not relevant, but second, the answer could be yes if you were in reasonable fear that the bottle or the water was something else. How many times across the spectrum of criminal defense cases do we see people using self-defense when something really isn't a gun or really isn't a weapon?
Right, right. Greg, I hope you will come back on the program again soon. You've been watching along in Tennessee this last hour. I know we have to let you go because you have some other obligations, but thank you kindly for that analysis. Thank you at home for being with us. I promise you're not going to miss a moment of the Curtis Reeves testimony. He's on the stand right now being crossed. We just have to squeeze in a break. We'll get you right back in where we're leaving off next.
No matter how healthy
Good Thursday afternoon to you and welcome to Court TV Live. I'm Julie Grant. Another busy day today as we're following major developments in several different cases happening all across the country. We're on a verdict watch in Minneapolis, Minnesota, where the 3 former police officers you see here on your screen are waiting patiently to hear the jury's decision. They're accused of violating George Floyd's civil rights. They're also accused in state court as well. That case was postponed till June, so this is not the end for these 3. They still have one other case that is hanging in the balance, but we're keeping our eyes on that courtroom. We're also following 2 other major cases. In Kentucky, former Louisville Metro Police Detective Brett Hankinson is on trial, charged with some low-level felony offenses that stemmed from the botched raid at the home of Breonna Taylor. He is not accused in her death. We want to be very clear about that. His bullets that he fired that night when her boyfriend fired first at police went into her neighbor's apartment. Thankfully, nobody was hurt, but that is what he's being charged with, wanton endangerment for those errant bullets. And as we continue, we want to go back to Florida. We're watching the defendant on the stand. We said all along there was a very good chance Curtis Reeves would want to take the stand, would want to get in front of this jury and tell his story. There's nobody better than him who can explain what was in his mind that day at the movie theater back in January of 2014 when he shot and killed Chad Oulson. He says it was in self-defense. The state says it was murder. We know it was all over the use of a cell phone, and we know some popcorn was thrown. You haven't missed a minute of the testimony. We're going back in together now, exactly where we left off.
So now you go to the manager, and at this point you've already had 2 contacts with Mr. Oulson, right?
Correct.
You get up, you have to walk past 2 sets of people. You have to walk past Jane, Roy, and you have to walk past the Turners, right?
Correct.
Okay. Obviously, you didn't know their names then, but there was 2 sets of people you had to walk by.
Yes, that's correct.
Now, when you're at the manager's desk, you tell the manager, I think your testimony was, he, meaning Mr. Oulson, doesn't seem to have the right attitude for me to try and talk to him again. You recall that?
I don't know if those were the exact words, but I indicated, I apologized to him first off that I had to come down there on a grown man. And then I told him that I had tried to get a gentleman that was sitting in front of me to turn his phone off, and he had used profanity, and I didn't think it would be appropriate for me to try to talk to him again.
And so did you tell the manager? Let me ask you this. You very well could have waited for the manager to go back into the theater with you.
He didn't offer to go back in the theater with me.
Okay, but you could have waited though, right? You had a conversation with him. You could have said, hey, I'd like you to come back, and I'm going to wait for you. There's nothing that prevented you from saying that.
The manager told me I could return to my seat.
Now, if you felt as though there was, that there was an issue with Mr. Oulson, obviously you would have waited.
At that point, there was no issue with Mr. Oulson.
So when you come back into the theater, now at this point, you reinitiate a 3rd time with Mr. Oulson. So we have the first time that you lean forward to talk about the cell phone. The second time is when you lean forward, tell him that you're going to the manager. Now we have a 3rd time where you're leaning forward to basically tell him that you told on him.
When I came back in, he was looking in my direction. I believe I said he was staring.
Okay. Well,
and he was.
Go on. Sure. Go on.
And he was speaking out loud. I don't know if he was speaking to his wife, or I think he was trying to. In my opinion, he was very loudly trying to proclaim that he was concerned about something.
Okay, let me ask you this. So you're saying now that he was staring at you?
Yes.
Okay, and obviously that was something that was important to you.
It caught my eye. It wasn't important.
Okay, well, didn't you testify that the reason that you said something to him when you came back from the manager was because he was staring at you? That was your way of just de-escalating it.
What I said was that he was talking out loud. I heard something about the theater and the manager, and that's.
I don't think you're. I want to make sure. Well, he's not answering my question.
Objecting. He's
Sustained. Give him a chance.
What I'm asking you is this. When you came back from the manager, you reinitiated with Chad Oulson. De-escalation. You go to the manager, you come back. You reinitiate another time, a third time with Chad Oulson, correct?
Yes, sir.
Okay, and the reason that you did that, I think you testified during direct, was because he was staring at you, or he was looking in your direction.
And he was talking out loud, speaking to the theater or to his wife, and he was commenting on that I had been to the manager.
Okay.
I didn't get all the words.
Did you tell Detective?
I'm going to object again.
Well, I'm just asking if about staring.
One at a time. That goes for everyone. Let him finish. Sustained.
Did you tell Detective Proctor that Chad Oulson was staring at you when you came back from the manager?
I don't recollect, sir.
Okay. Would it refresh your memory to take a look at your post-Miranda statement?
Sure.
May I approach the witness?
You may.
I'm going to give you both statements so that you can review both of them. After you finish reading them, let me know.
Do you want me to review the whole thing?
If you can review as much as you want to refresh your memory as to whether or not you told Detective Proctor.
Can we have a page and a line?
There is no page and there is no line.
Well, there is a page, but you have to give us some kind of line. If not, we're going to be here for 30 minutes just to read the whole thing.
Okay, I can rephrase it. Would it surprise you to learn that nowhere in your post-Miranda statement did you ever tell Detective Proctor that Chad Oulson was staring at you when you returned back from the movie theater? Sorry, from the manager.
Probably not, no, sir.
Okay, so what I'm asking you is this. You never told Detective Proctor that Chad Oulson was staring at you when you came back from seeing the manager?
I don't think so, no, sir. But I'm not sure.
Okay, well, that's why I want you to refresh your memory with your statement. Look in there, and if at any time you see that Chad Oulson said, or that you told Detective Proctor that Chad Oulson was staring at you, to let me know. I don't want you to guess about anything. Take your time and read through your statement.
You want me to read this whole thing?
Yes.
Okay.
All right, while we have a break, just want to say I don't know if the juice is worth the squeeze here with this, because prosecutors trying to establish a point that really isn't all relevant, whether he was staring or not. The witness could easily explain it by saying he was never asked the question of whether or not he was staring at him. But again, it doesn't go to the heart of the issue. The real issue is whether the homicide was justified, not whether Chad Oulson was staring at him when he came back from speaking with management. Let me bring in our use of force expert on the show today, David Wright. Dave, you've taught us about all the different elements that make up your assessment of use of force. What are you thinking so far as you're seeing Curtis Reeves testifying?
The testimony is very fascinating. I took some notes here, and clearly the defense is trying to establish the elements of deadly force, that they are present. And so, for example, ability. The defendant said, in terms of the deceased, he was enraged. He had size on me. So they're establishing, hey, that he had the ability. And then in terms of opportunity, the second point of the elements of deadly force to be justified in the use of deadly force, he states he was on top of me. And that goes to that, that close quarter. And then imminent fear. It's the end of the line for me. Hey, now, preclusion.
David Wright, thank you so much. Let's go back in and listen.
Because he was talking about me going to the manager.
you can look at the post-Miranda statement that's in front of you. I'm directing you to page 6. Lines 19 through 22. Tell me when you're finished reading that to yourself.
I finished.
Okay. So when you came back from the manager, you went over and you saw that Mr. Oulson had put his phone away. And when you went by, I said, I see you put the phone away. I told the manager for no reason. In other words, I went in and ratted you out.
Well, I mean, I went in and ratted you out was my comment, not what I said to him. He's the one that he wasn't talking to me, he was talking to someone else. I guess I was responding to what he said. I was trying to de-escalate because it seems like with the stare and the other stuff that he was still concerned.
In your statement to Detective Proctor, the one that you just read, you did not tell Detective Proctor that you overheard Mr. Oulson or that Mr. Oulson in any way said anything to you. You said that when you came back from the manager, you were the one that reinitiated, correct? That's what's in the post-Miranda statement.
Okay, yes, sir.
Okay, I don't want you to just agree with me. I want you to look at it.
I did.
Okay, so when you told Detective Proctor, or when you spoke to Detective Proctor, you told him you reinitiated with Chad.
I told him, when I talked with him on the phone, I can quote it if you like.
It says, I came back into the movie, the guy put his phone away, I went by, I said, I see you put it away. I told the manager for no reason. Correct? That's what it says?
Yes, sir.
Okay, so what I'm saying is it doesn't say anywhere that you heard Chad saying something and that you were trying to de-escalate. It doesn't say that anywhere in the statement.
Okay.
So going back to my original question, this is the third time then that you yourself reinitiated with Chad Oulson.
That would be the indication based upon what I heard him saying.
Okay, but again, and I'm going to move on, you never told Detective Proctor that you heard him say anything.
Correct.
And obviously, you didn't perceive yourself as a vulnerable person because this is the third time that you have initiated contact with Mr. Oulson.
I don't think it had anything to do with being vulnerable.
I agree with you. Now, when you had come back, Chad had turned his cell phone off, right?
I have no idea.
Okay. Well, if you look in the same exact spot that I was just referring to refresh your memory, is that page 6, lines 19 through 22? Okay. When you had come back, Chad Oulson had turned off his cell phone, correct?
It says here that the guy had put his phone away.
Okay, so he had put his phone away.
I have no idea if it was off or on. I didn't see it.
Okay, but he put it away. All right, so he did exactly what you wanted him to.
I suppose, yes, sir.
So at this point, everything was fine?
As far as I was concerned, yes, sir.
Okay. Now, you were wearing sneakers that had reflective material on it on that particular day, correct?
Yes, sir.
May I press record?
You may.
I'm showing you what's been admitted into evidence as State's Exhibit number 50. These are the sneakers that you're wearing on that day?
It appears to be, yes, sir.
Okay. And on the sides or on the back is where the reflective material is?
I think on the outside. I can't really tell. But whatever the gray area is, I think it reflects.
So in the back, you see the gray area?
Yes, sir.
Okay, so wherever it's gray, as you indicated, that's the reflective material.
I don't know if it's all reflective or not.
Okay, well, you know that your shoes reflected light on that day, correct?
Only because the sheriff's office took a bunch of pictures.
May I have the witness step down and use the TV?
Yes.
Gentlemen, may I reposition myself?
You may.
Oh, I don't know why you would ask the witness you're crossing to step out of the witness box. We have to hit the pause button. You're not going to miss a moment of this. We're going to step aside for a break. We're back into the courtroom for more of the cross of defendant, former police captain Curtis Reeves, now accused of murder.
Tonight at closing argument.
Welcome back to Court TV Live. I'm Julie Grant. Thank you so much for being with us as we're watching the cross-examination of defendant Curtis Reeves. He's accused in the movie Popcorn murder trial. He says he shot and killed Chad Oulson in self-defense because he was in fear of his life. We're going to go back in. The prosecutor has just asked him to step off the witness stand. That's a big trial advocacy no-no. Apparently he's going to show him something on the video, and it could be tough to get him back in the witness box, and he's going to be closer to the jury now, which could be advantageous to him. Let's watch.
In state citizens, what? Is this number 2? I'm referring to State's Exhibit number 2 for these questions for the record. You see yourself standing up over here?
Yes.
Okay. And when you stand up and you start to walk, everybody see? You can see a reflection on the bottom of your shoe, correct? See that right there?
Looks like it's on the outside of the right foot, yes.
Okay. You see yourself sitting right here in the back row?
I think, yes, sir. I think I see my wife and...
Okay. And this is you with the popcorn in the back row?
I think so.
Okay. Now, when you sat down, you took your right leg and you crossed it over your left leg. Correct?
That looks like it's in front of my wife's face, sir. And I don't know if I crossed my leg or not, sir.
Okay, but what you can see here is you crossing your right leg and your shoe reflecting from the light. Correct?
I don't know, sir. That's an odd angle. I can't tell that.
Okay, well, the light is moving with the leg. Correct? Okay. Well, I'm asking you.
I don't, sir. The popcorn bag was bright. I don't know. And as far as I know, the experts don't either.
Okay, well, I'm just asking you if that's your leg moving.
It appears to be, yes.
Now, you're coming back from the manager at this point. I'll play a little bit more. You're coming back, and you're sitting back down. You grab the popcorn, right? Okay, and that's you?
Yes.
All right. So if you look in the bottom left-hand corner, you can see another reflection down here, correct?
Yes, sir, I think so.
Okay, and it's moving at the same time that your leg is moving, correct?
Yes, sir.
Okay, much like when you were moving your leg and you put your right leg over your left leg before, we see the same movement with reflection, correct?
I don't know that I put my right leg over my left leg, but it looks like the outside of the shoe, yes, sir, I think.
Okay.
Yeah. It looks like it's maybe the side or something.
This is when you come back from the manager. Now, obviously we just watched, that was you that sat down, correct?
Yes, sir.
Okay, so when you sat down, in this particular frames, you once again put your right leg over your left leg, correct?
I don't recollect that. I don't recollect crossing my legs.
Okay, is it a possibility?
I suppose it is, or the popcorn bag, or I don't know. Well, right there, you see Mr. Oulson throwing something. That would be a pretty good indicator to me.
Okay, did I ask you a question about that just now?
You asked me what I saw in the video.
No, I was asking you about the reflection on your shoe. We're going to get to the whole event. Okay, don't worry about that. I'm just asking you about the reflection on the shoe.
I have no idea.
Now, there's been a suggestion that at some point in time you were hit maybe with a cell phone or a fist at this point in time, correct?
I don't think it was a suggestion, it was a reality.
Okay, and we'll talk about that. But in looking at this series of events, you had come back from the manager, you're sitting down in the seat, and when you sit down, you crossed your right leg, and that's the reflection that we see. Would you agree with me that when you're moving forward, the reflection is your right leg going down?
At the same time, Mr. Oulson is entering the frame, and I don't know, sir.
Okay, well, what I'm asking you this. You've seen the previous frames where every single time you're moving, we see that light source moving. Now here we are in this series of frames, and the light source is once again moving when you're moving the right leg. Isn't that correct?
I see it on the bottom of my shoes, yes, sir.
Okay, so what we see here is your leg crossing and uncrossing, and that's exactly what the white light is.
I don't see, I see my leg crossing, I don't see it. The light is at the same time Mr. Oulson is coming across.
Okay, well, Mr. Oulson wasn't in the last series of clips that I showed you when the light source was moving with your phone, was he?
Those were pretty apparent.
Okay, well, looking at this one, you don't see your right leg moving?
I see my right leg coming up, yes, sir.
Okay, and you see at the same time that your right leg's moving, you see that light being
I see it on the floor, yes, sir.
Okay.
I don't know if I cross my legs or not, but I see it on the floor, just like I did in the other view. It's on the floor.
Okay, now let's take a look at this one. Now, at the bottom right-hand corner, okay? So this is where I'm going to be directing your attention.
I see.
Okay, right over here. Do you see that light reflecting?
Down below my wife?
Correct.
Okay. Yes, sir, I do.
Okay, you see it? Now, is it a coincidence that your right leg is once again moving at the time that we see that light?
I'm getting away from him, and
I'm not asking you what way you're moving. I'm just asking you about the reflection of your shoe when you're moving your leg. In other words, every single time that you're moving, in all the clips that we've seen, that's when you see the reflection.
that looks like it's on the right-hand side of my wife.
Okay, but aren't you moving at the same time?
So is my wife.
But are you suggesting to the court that that's your wife's shoe?
I'm suggesting to the court that that's my wife moving next to me.
Okay, I'm not asking you if your wife's moving next to you. I'm asking you about the reflection when you're moving, consistent with all the other times there's a reflection when you're moving.
There is a reflection below my wife, or looks like to the right of my wife, and I'm moving and she's moving.
And in fact, talking about your wife, she's facing Mr. Oulson at that time, correct? But as soon as the shot's fired, she looks to the left.
I can't tell head direction there.
And you can't tell that she's looking straight here and then looking right at the shooting.
No, that's right.
You can't tell that.
I can see the compliment.
Okay, and you can also obviously see the reflection down here.
I see a spot down there by my wife. Yes.
Okay. The fact of the matter is, based on what we demonstrated. At no time was a cell phone thrown at your face at the time that you had come back from the manager. That's simply the reflection of your shift.
I don't think there's nobody that can answer that but me, and I got hit in the face.
We're going to be using this in a little bit to go through what happened if you when my attorney.
What'd you think of that? Tweet us. Let us know. We're hitting pause. We're going to get you back into the courtroom for more of the cross as the defendant makes his way back to the witness stand. This is Court TV Live, your front row seat to justice.
This is an important
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. We are watching the defendant testify in his own defense in the movie Popcorn Murder Trial. He's a former police captain, did 27 years on the force in Tampa. Right now, he's being cross-examined by the state. Thank you for all your questions and comments on Twitter. Got a great one when I said, why wouldn't it be a good idea to take him out of the box? Well, that is because when you're on cross-examination and you're the lawyer, you want to be the star. You don't want the jury's focus to go on anybody else but you, and that includes the witness. You want to keep the witness in the box so that you can box them in to their answers. We're going to go back in and pick up exactly where we left off before the break.
Isn't it showing on my screen too? Yeah. Okay, then I'll
Now, I believe you indicated on direct examination that you had said, and correct me if I'm wrong, you had said to Chad that you were sorry for telling on him.
Something similar to that.
Okay, well, what's similar? Did you say I apologize? Did you say I'm sorry?
When I got back from the manager's office.
Correct.
Yeah. Sorry, I don't know exactly what I said.
Okay. Well,
it was an effort to diffuse any situation that might be there.
Okay. When you spoke to Detective Proctor, you never told Detective Proctor that you apologized to Chad in order to try to de-escalate the situation, did you?
I don't know that I called it an apology, no, sir.
Okay. Well, let's not play word games because it's really important. And I don't mean to be sarcastic. Okay. Did you say?
Move on.
Did you say, I'm sorry, I apologize, or any word whatsoever that would give an indication that you were sorry or apologizing when you spoke to Detective Proctor?
When I spoke to Detective Proctor, I told him that I did speak to him when I came back.
Okay, but you didn't specifically tell Detective Proctor that you apologized to Mr. Oulson. You said you're sorry to Mr. Oulson. Any words of that effect? That's the question that I'm asking you.
I don't think so. I think I told him that I don't know that I formed it as an apology, but...
Okay, but you didn't say anything at all like that?
I don't think so. To Detective Proctor, right?
Correct. All right, so let me ask you this. How many times are you saying that Mr. Oulson attacked you? Twice?
I think we were, at the time, he either hit me in the face, and I suspect very, very, very strongly, rather than a fist, it was a phone. And then you saw him grab the popcorn. I was not aware of the popcorn, but I was aware that he was trying to grab a hold of me.
Okay, so...
And then he pitched it back. I'm not sure I saw that, but I did see him coming over the seat with his fist at the instant he got shot.
Okay, we're going to talk about all of that, okay? I'm asking you how many attacks there were. So based on your answer just now, you were saying that there were 2 separate times that you were attacked by Mr. Oulson.
Correct.
All right. And the very first time was when you came back from the manager, correct?
Yes, sir.
And that's the time that you're saying that it was a fist or a phone, correct?
Right.
And you're saying that you strongly believe it was a phone.
Very strongly.
Okay, so you must be saying that by getting hit with this phone, it must have been so hard that you actually realized that Mr. Oulson is a danger to you. In other words, if he tossed the phone at you or dropped the phone towards you, it wouldn't be a big deal.
He hit me in the face. I saw him as a threat at that point, and I tried to get out of his way.
Okay, so he hit you in the face. Your testimony is with a cell phone.
Yes.
Okay. Now, isn't it true that you told Detective Proctor that you weren't sure it was a cell phone, and in fact, you only put 2 and 2 together, so to speak, when you looked down and saw a cell phone?
That's pretty much accurate, yes, sir.
Okay. So today you're testifying, I'm fairly certain it was a cell phone, but the day of the shooting, you told Detective Proctor, I don't know what it was. I looked down, there's a cell phone. Must have been a cell phone, right?
At the time I interviewed with Detective Proctor, I had not seen the video.
Well, why would you have to see the video? You lived it.
My impression at the time that I was hit was that he was perhaps too far away for a fist. When I saw the phone, I put two and two together. He hit me in the face with his phone.
Okay. So a minute ago, you said you hadn't seen the video. So you're not telling us that you're tailoring your testimony to what you witnessed in the video, are you?
I think the video is supporting my position.
Okay. Even though it's been shown that the reflection was clearly your shoe?
I don't think at every instance it's been shown that way.
Okay. So you're indicating that there are two separate times. Okay, so let's talk about only your post-Miranda statement with Detective Proctor. Then we're going to talk about this additional attack. Let's talk only about your statement to Detective Proctor, okay? All right. To Detective Proctor, you indicated that you had come back from the manager. You already need you to refresh your memory?
No, I'm sorry. Yes, sir, I had come back from the manager.
Okay. So you indicated to Detective Proctor that you had come back from the manager and you had reinitiated with Mr. Oulson, even though he had put the phone away, correct?
I think, yes, sir, that was pretty much it.
Okay. And obviously you could have just gone and sat in your seat and not had any conversation at all with Mr. Oulson.
Except that I heard him complaining about the manager.
Okay, and we've already established that's not in this post-Miranda statement.
That's correct.
All right. So assuming that didn't happen, just for the sake of my question, because it's not in the post-Miranda statement.
You're going to object, Your Honor. You can't assume that it didn't happen. He's testifying just the opposite. That calls for speculation at this point.
Oh, sustain.
So you come back from the manager and you sit down. Now, the words that you use to Detective Proctor are as follows. Chad turns around in his seat. You recall that?
Yes, I do.
Okay. And the word in means he is in his seat and he turns around. Correct?
In my statement, I believe I was interrupted by a deputy who brought me a drink. And when he turned in his seat, he stood up.
Okay. If you need to, refresh your memory with the post-Miranda statement transcript.
I do.
Okay. All right. In there, you told Detective Proctor, when I came back, Chad turned around in his seat.
Yes, sir.
And then you discussed something that we're going to get to in a second that happened right after that, correct?
The deputy handed me a drink that had a pile of ice on top of it. It kind of interrupted the conversation.
Okay. Really, this is what I'm asking you. You said that Chad turned around in his seat. Forget about when the deputy interrupting you after the fact doesn't mean anything. Your language, your word.
Object, move to strike. It does mean something. For him to be testifying what it means and what it doesn't mean is from the witness stand that means something.
Let's rephrase.
Prior to being interrupted, you used the words, Chad Oulson turned around in his seat.
Correct. And stood up. Not on the deposition.
Yes, Your Honor, I haven't asked the witness a question. All right, I'm going to direct your attention to page 6, lines 26 through 37. Read them to yourselves and let me know when you're finished, please.
Through 37.
Page 6, lines 26 through 37. Just read them to yourself and tell me when you're ready.
Well, this cross has me on the edge of my seat. How about you tweet us? Let us know. We're hitting pause. You won't miss a moment of this testimony, I promise. Also, if you're interested in watching the Hankinson trial in Kentucky, we have that streaming. Just go to courttv.com. You can see that all there if you like. We're so glad you're with us on this Thursday afternoon. Stay right there.
Tonight, at closing argument.
You're watching Court TV Live, your front row seat to justice. I'm Julie Grant. Let's go back to Florida together now. We hit pause. Now we're going to pick back up. We're on the movie Popcorn Murder Trial and the cross-examination of the defendant. He's chosen to take the stand. Remember, in any criminal case, the defense never, ever has a burden of proof. When you're alleging self-defense, which is an affirmative defense, as it's called, a justification defense, there's just a burden of production, a preponderance of the evidence standard. The burden stays on the state to disprove that the accused shot and killed for fear of death or serious bodily injury. Remember that. So we continue watching more right now.
337.
Yes, sir.
Okay, so when you read that, going in chronological order, because I would assume you're explaining it in chronological order.
No, well, no, sir, I wasn't, but I understand.
Okay. So when a detective is asking you to explain what had happened in a shooting where someone died, and with your background, training, and experience, you're saying that you weren't explaining it in chronological order.
I think if you read the whole thing, I was probably in shock for what had just happened. And there's a lot of things that are injected at different places.
Okay. All right. So let's read through this. So
okay.
Starting in line 19, you indicate that you had gone back into the movie. I came back to the movie. The guy had put his phone away. When I went by, I said, "I see you put it away." I told the manager for no reason. In other words, I went and ratted him out. If he was going to put it away, I would have gone and and Detective Proctor says right, and you say makes sense. And he turns around in his seat and. Then you talk about a drink.
Right.
Okay. Then you said, and he...
Object, it's either impeachment or it's not impeachment. Improper predicate for whatever he's doing.
Your Honor, the witness wanted to be placed in the context, and this can only be placed in context by reading this.
Well, there's got to be a question, and he's got to have the opportunity to answer. So ask the question and let him answer.
Okay, so we already discussed the exact wording. He turned around in his seat. After that, and I'm specifically speaking on page 6, line 36, you indicate, we're starting on 35, when I had come back, that's when he had said that. His wife is holding him back, so I had sat down. I think I got the bag of popcorn from my wife, and so he jumps up and turns around.
Yes, sir.
Okay. So you had originally indicated that he turns around in his seat, and after he had turned around in his seat, you indicated he had jumped up. There'd be no reason for him to jump up if he turned around in his seat, correct?
I would say that probably he turned around and jumped up all at the same time. It was one motion.
Okay. But what you stated in this statement was, when I returned from the manager, we came back. His wife was holding him back, so I had sat down. I got the bag of popcorn. He jumps up and turns around. Now, let me ask you this. May I briefly have the witness step down again?
You may.
Publish 2 pictures in front of the jury. I'm going to be referring to Defense Exhibit 9. It's like 9-1 and 7-3.
Were they admitted?
Yes, Your Honor.
That's not what they came in. Is it 9 a composite? Yes.
No, it was a 9.
Okay, all right. So it's a composite 9 and those are the individual pictures.
I'm going to have Mr. Reeves stand next to me.
Okay.
Looking at, first we'll look at them together, and then we're going to show them to the jury. Looking at 7-3, the timestamp on the bottom is 13/26/25, correct?
Yes, sir.
Okay. So, 322. Okay. So this happened closer in time than this one because this is 132636.26 says. Correct?
This one's first.
This one was first because this is 25 here. Okay, and 36 here. Okay, so this one happened first.
Okay.
All right. Now looking at this is when you're saying that a cell phone hit you. Is that correct?
Yes, that's what it appears to be. Yes.
Okay, that's what you're testifying.
Because I can see Mr. Oulson's arm all the way across the back of the seat, or back
Behind his seat. Yes.
Correct, and that's what we're going to be talking about right now. Okay. So, would you agree with me? And we'll turn and show. I'll show you first, and then we're going to show the jury. Let me ask it this way: was he standing at this one time?
It happened so quickly, I'm not sure. I think he was. He was either in the process of standing or whether he turned and stood or stood and turned. I'm guessing he jumped out of his seat and flipped around.
Okay, so I'm just trying to make it clear. Was he standing or he wasn't standing?
I don't know.
Just give me just 1 second. I'm going to show you, this is page 1850, lines 10 through 14.
I can't hear you.
You want him to read it to himself?
Yeah, just read it to yourself. 10 through 15, see if that refreshes your memory about when you returned from the manager, if you indicated that he was standing up.
Not sure what the prosecutor's trying to do here. This is definitely unconventional. Not sure why he's got him standing next to him, but we're hitting pause. You're not going to miss a moment of this. We have our crew in the courtroom. They're going to be bringing us analysis and the jury's reaction to everything we're seeing on the cross. So we head into our next hour. Big thank you to use of force expert David Wright as well. Stay there. We'll be right back.
The following information is for
Thank you for spending part of your afternoon with us here on Court TV Live. Welcome back. I'm Julie Grant. We're covering major trials across the country. We're in a verdict watch in Minnesota for the 3 officers accused of violating George Floyd's civil rights. We're in Kentucky with the trial of former officer Brett Hankinson. He's accused as part of the raid that took place in the home of Breonna Taylor, but to be clear, not accused in her death. We've got that streaming right now for you on CourtTV.com if you want to take a look at that trial. Right now, let's head back to Florida together. The jury just got a look moments ago at those 2 photographs that counsel was showing the defendant. They were still frames that were taken from that surveillance video inside of the theater. Counsel clearly trying to make a point with the light reflections, clearly trying to contradict what the defendant is saying about the timing of the hit to his face, he said, that happened by Chad Oulson with his cell phone. Let's watch.
Just to clerk. Okay, we're going to keep going with your statement that was given the day of the shooting to Detective Proctor. We're going to go in order, okay?
Okay.
So, you come back from the manager. We're not going to have a discussion about turns around in the seat anymore. After that, you indicate that Mr. Oulson jumps up, correct?
At the same time, we're talking about, I don't know, we're looking at the videos that are in milliseconds. So I think in real life, we're talking about milliseconds between standing and jumping up. Yes, sir.
Okay. So my question to you was, after you said that he had turned around in his seat, he had now jumped up. So that's the point that we're at.
He's on his feet, yes, sir.
Okay.
And he's turning around and he's facing me.
Okay. And you indicated to Detective Proctor that the moment he jumped up, the popcorn went by the wayside almost immediately.
I didn't know what happened to the popcorn.
Okay. Didn't you tell Detective Proctor that immediately when he jumped up, the popcorn went by the wayside? Whether he took it from you or you yourself dropped it or it accidentally fell, it doesn't matter for the purposes of my question. My question to you is this. After you said that Chad Oulson jumped up, you said that the popcorn went by the wayside immediately. Do you remember saying that to Detective Proctor?
I believe I do, yes, sir.
I didn't hear your answer.
Yes.
Okay, so according to you, immediately upon Chad Oulson jumping up, the popcorn fell. Let's talk about what you said, Detective Proctor, after the popcorn fell. After the popcorn fell, you told Detective Proctor that Chad Oulson was virtually on top of you.
Correct.
So after the popcorn fell, he was virtually on top of you. Now, virtually on top of you would mean that he was basically in your row, virtually on top of you, correct? That's what you meant when you told Detective Proctor.
What I meant by that was that I was seated. He was standing over me. He was a giant. I have no idea if he was on his seat. I don't know. He was leaning over the back of his seat. Yes,
okay.
Sir.
Now, when you say leaning over the back of the seat, wouldn't you agree with me? That's a lot different than someone that's virtually on top of you.
That would be my interpretation of somebody who's attacking me. Yes, sir.
Okay. You've been in law enforcement for a long time, right?
27 years ago now, almost 30 years.
Okay. You written police reports in the past?
30 years ago.
Okay. So how many reports do you think you've written? Thousands and thousands and thousands of reports?
I have no idea.
Okay. I mean, what I'm saying, though, is you haven't written 3 or 4.
No.
Okay.
Correct.
And in fact, as a supervisor, you probably reviewed reports of officers that were under your command, correct?
Correct.
And when you're reviewing reports, you're making sure that the reports are very accurate, very detailed, because you know that both the state attorney's office and defense attorneys are going to be looking at those reports to find out truthful and accurate information. Is that correct?
Yes, sir. You're reviewing it for content.
Okay.
Because you weren't at the scene, you don't know how accurate it is.
Okay, but you're reviewing it to make sure there's sufficient information and it's detailed because you know how important it is.
Correct.
Okay, and when you authored your own reports, you certainly wanted to make sure that the words you choose were extremely critical and that the words you choose were very accurate, correct?
35 years ago, yes.
Okay, so you're saying now you don't think it's important to be accurate with your words?
I use different words now.
Okay, I'm not asking you what words you use. I'm talking about the actual words that you use. It doesn't matter what the words are. It's that you're accurate whenever you speak. In other words, here you are describing an event where you believe, and we'll get to it, that you're in a life and death struggle, right? Wouldn't you agree with me that the words that you choose, the content, is so incredibly important?
I would think that the content, if it relays the feeling at the time, I'm not sure. Everything is important in this kind of an investigation.
Okay, so here's what I'm getting at. Today you're saying leaning over. Back on the day that this event happened, you tell Detective Proctor he's virtually on top of you.
That would be similar, yes, sir. They would mean essentially the same.
Really?
Yes.
Leaning over and actually on top of you to the point where you think you have to kill someone is the same thing.
I think you're trying to make it sound like he's physically on top of me.
Okay.
He was attacking me. He was very large. He was trying to come across his back seat. That would be my analogy of virtually on top of me. Yes, sir.
Okay. And you indicate that while Chad Oulson is virtually on top of you, your left hand is out, and you're yelling, no, 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 or whoa, whoa, whoa.
I am trying to dissuade him from coming across, and my thought is, yes, that my hand is in front of me.
Okay, and when you read all these sentences that we're breaking up together, this is the picture. Chad Oulson is virtually on top of me, so I have my left hand out. Now,
I said it was in front of me. I'm sorry.
Okay, well, let's just keep going through the statement.
Okay.
After that, isn't it true that you say, I'm holding on, I'm touching something, it's his chest, or it's his arm?
I wasn't sure. In retrospect, I think that's when he grabbed the popcorn, he hit my hand.
Okay, we're not talking about in retrospect. At the time that you gave the statement to Detective Proctor, at the time, closest in time to the event of when you shot and killed Chad Oulson, didn't you tell Detective Proctor that Chad Oulson was virtually on top of you?
Yes.
You have your left hand out. He's virtually in your lap, and you're touching his chest and his shoulder area to give the impression that he is on top of you, and that's why you're going, whoa, 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 and no, no, no.
That's correct.
And at that time, and again, this is all after the popcorn fell.
Again, the popcorn, I had no idea where it was.
Okay, I'm not asking you if you knew where it was. Based on your statement, you said when he jumped up, the popcorn fell immediately. All of this that we're talking about is after the popcorn fell, according to you, Detective Proctor.
Okay.
Okay. I don't want you to just agree with me. That's what you said in your statement.
Okay.
So now, to Detective Proctor, you said that suddenly your head was to the right, you were hit with something, you assume it was Chad Oulson's fist, correct?
Or something thrown at me.
Okay.
Yes, sir.
Now here's where I'm going with this, because right now we're only talking about your first statement to Detective Proctor, right?
Oh, okay.
All right. I mean, that's what we've been doing this whole time, right?
Right.
All right. Now, in a while, we're going to talk about the statement that you made today in court, where you're saying this whole event about being hit was right after you came back from the manager. A whole separate time, 9 seconds before. But on the day of the shooting, you're talking about this happening after the popcorn had fallen.
That's not what's in this statement. This is not what this jury heard earlier in audience.
Approach.
Ooh, what do you think so far? Tweet us, let us know. I want to bring in my guest who's on the program to give us some analysis now. Criminal defense attorney Josh Schiffer. He practices in Atlanta. Josh, if you are defense counsel, how are you feeling about your client on cross right now?
You know, I'm pretty happy because he's standing up, he's being authentic, he's being the real person. Problem is that real person could be really offensive to some jurors. I think that this testimony is obviously going to be self-serving. As I was just explaining to a client this morning, anytime the defendant, the actual accused, is going to testify, the jury automatically is going to say, hey, all this testimony is going to be super biased in their favor. But then you get to the actual personality involved. And Defendant Reeves has the personality of a longstanding police officer, and he's pushing back in a way that I feel might offend some jurors.
Okay, let's expound more. Oh, you know what? I see the prosecutor back at the podium. Let's listen. Josh, thank you.
Page 7.
Absolutely. Thank you.
To put this in chronological context, you can look at page 6, just the very bottom. On page 6 at the very bottom, that's where we talked about that Mr. Oulson had jumped up. Is that correct? Are you on page 7 now?
Yes, sir, I am.
Okay, so at the bottom of page 6, it discussed where you said that Mr. Oulson had jumped up, correct?
Yes, sir.
Okay, now we're on page 7, so we're just going chronologically.
Okay.
If you look at lines 11, 12, and 13, it's at that point that you indicate Mr. Oulson had jumped up, and now he's virtually on top of you, correct?
Judge, I'm going to object and ask on the doctrine of completeness for him to read 1, 2, 3, 4, 5, 6, 7, and to go all the way to that under the doctrine of completeness.
I'll read the entire thing.
Okay. Sustained.
Okay. We're just going to read through page 7. He's pushing back. There's a crack between us. I'm leaning back in my chair. I got nowhere to go. And if just follow along, so if at any time I say anything incorrect, let me know.
You're on line what, sir?
And then now I'm on line 8, page 7.
Okay.
This is you.
All right.
I'm leaning back in my chair. He kept on hollering. I'm not sure what was said, to be honest with you. He said something that led me to believe he was going to kick my ass. I don't know if that's exactly how he phrased it or not, so I'm looking briefly, and I can't go anywhere. Now, here's the part that we were discussing. I'm leaning all the way back in my chair to get away from him. Suddenly, he's virtually on top of me. So we went from Mr. Oulson jumping up, then what we just talked about, and he's virtually on top of you, right?
He only jumped up once and turned around. Yes, sir.
Okay, but we're still talking about after the popcorn drop.
I don't know when the popcorn left. I'm sorry.
Okay. We had already established that you said that as soon as Chad Oulson jumped up, the popcorn went by the wayside immediately, right?
But I don't know at what point.
Okay, immediately.
Okay.
Okay, I mean, immediately is the point. When Mr. Oulson jumped up, the popcorn went to the wayside immediately. That means right then, correct?
Okay.
Your Honor, I'm going to object again. That is not in a chronological base on the transcript.
Your Honor,
there is nothing that
Overruled.
So you indicate that you're going backwards, correct?
I'm going backwards because he's coming at me. Yes, sir.
Right. Okay. And you indicate that he's virtually on top of you. Your left arm is out in front of you. You can read, this is lines 18 through 25. And you're saying no, 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 or whoa, whoa, whoa. So while you're back and he's virtually on top of you, your left hand's out. You're yelling no, 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 or whoa, whoa, whoa. And at that time, that's the time that you're saying you were struck in the head.
No, I was struck in the head as soon as he turned around.
Okay. Well,
instantly. I mean, there was nothing that preceded that.
Okay. Read lines.
Oh, you're not going to miss a moment of this. We're hitting the pause button. We just have to take a break. Thank you for spending part of your Thursday afternoon with us. We'll be right back with more of the movie Popcorn Murder Trial after this. So glad you're with us this Thursday. Welcome back. I'm Julie Grant. Let's go together to Florida now. We want to watch more of the movie Popcorn Murder Trial. Today is arguably the biggest day of this trial because the defendant has chosen to take the stand in his own defense. We're picking up exactly where we left off right now.
Lines 18 through 21. I'll read it to you. And you're sitting down, and there ain't no way to get out. So I'm stretched out, trying to get away. My left arm is out in front of me. I'm either saying no, 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 or whoa, whoa, whoa. Suddenly, my head was to the right, so he hit me with something. I assume it was his fist. With his fist or something. I think he had his cell phone in his hand. I saw the blur of the screen.
Yes, sir.
That's my point, Your Honor. That is the correct one. He is trying to impeach him on something.
Your Honor, I would object to the speaking objection.
Sustained. I mean, overruled on yours and sustained as to speaking objections. You can approach, but you don't need to right now.
The picture that you have painted for Detective Proctor, and again, this statement is in evidence. The members of the jury can listen to themselves, okay? You indicate that when he jumped, the popcorn went by the wayside immediately. After that, you're explaining that Chad Oulson is virtually on top of you. You're leaning back. You have your hand out yelling, whoa, whoa, whoa. And it's at that time you're struck. That's what this statement says, correct?
Let me think about the time frame here for a minute. The first time I was hit was preceding anything else. This time that I'm this is what I mentioned earlier about jumping around. I know what this says, but I also know when I was hit. I don't have an explanation.
Okay, so you don't have an explanation as to why your statement to Detective Proctor on the day of the shooting is so different than today.
I think that I was excited. I was scared. I think that once you have adrenaline going in your system, I may have confused one item with another. This happened over a period of seconds. I mean, virtually seconds, and in my mind, much quicker than that.
Okay. Would you agree with me that the powers of observation fade over time?
I would agree that, yes, that would normally be the case.
Okay. In fact, the phrase that I just used, the powers of observation would fade over time, is the phrase you yourself used in this statement with Detective Proctor.
Okay.
Would you agree with me?
I would agree with that. That's factual.
So we're 8 years past the time of the shooting, correct?
Yes, correct.
And if the powers of observation fade over time, it's kind of interesting that today you have added a quote-unquote second attack. Now, the reason, and I'm asking you this, wouldn't be the reason that you added the second attack is you're trying to justify this shooting by making an attack appear to have occurred 8 seconds prior, when in your statement to Detective Proctor, it occurred after the popcorn had fallen on the ground.
I never put the two together. He only hit me one time, and then he was reaching for me the other time, just like when he was shot. He was reaching for me.
I understand. And the jurors have the post-Miranda statement, and they listen to your testimony.
Right.
Okay. And the stories on their post-Miranda statement and today are very different.
We're dealing in microseconds today, and I was dealing with stress then.
Okay. Well, 8 seconds isn't microseconds.
I don't know anything about 8 seconds.
We'll get there in a little bit.
Okay.
Now, you indicated that while your left hand was out, because Mr. Oulson is virtually on top of you, you believe you were touching his shoulders or his chest because he was virtually in your lap. Do you remember saying he was virtually in your lap?
I do.
Okay, and that's why you're touching him, because the picture you're painting for Detective Proctor is he's on top of you. And you indicated in your statement to Detective Proctor that you were surprised you didn't shoot your own left hand, correct?
I was, yes,
okay.
sir.
That's because it was out in front of the gun, correct?
That was my perception, yes, sir.
Okay. Now, you'd agree with me that had your hand truly, really been in front of the gun, there'd be stippling all over your left hand.
The gun was in a, I think you guys call it index shooting position. It would have been very close to my body. It would not have been extended. It would be pretty close to my right hip.
Okay, you're the one that said you're surprised you didn't shoot your left hand, right?
Yes.
I didn't make that up. You said yourself you're surprised you didn't shoot your left hand.
That's correct.
Okay, because the gun was in a position where the bullet would come out and shoot your hand. So your hand had to actually be in front of the muzzle. That's the only way you could be afraid you'd shoot yourself.
Your illustration of having your hand straight out in front of you is not what my thought was. My thought was it was down by my hip, and my gun was down by my hip. So all this sticking your hand straight out in front of you had never crossed my mind.
Okay, but in your statement, you're saying that you have your left arm out and you're surprised that you didn't shoot yourself.
Okay.
I mean, there's no way around that.
Perceptual distortion.
Okay. Or is it you're trying to justify a shooting that's not lawful?
That would be a fabrication.
Correct.
For you.
Now, based on just Detective Proctor's statement, you indicated to Detective Proctor that you were hit on the left side of your face, correct?
Yes, sir.
Now, today here in court, you said it was over your left eye, correct?
That's the left side of my face, yes, sir.
Okay, well, wouldn't you agree with me there's a difference between over your left eye and the left side of your face?
I think they're both located in the same place.
Okay, I really don't mean that. I'm truly not being sarcastic, okay? Over your left eye is over your left eye. This is the side of your face. You can't be telling this jury that over your left eye and the left side of your face is the same exact position, are you?
I never thought about a distinction between what you just illustrated. The left side of your face is the left side of your face, or your left eye is the left side of your face. I never differentiated between the two.
So there's no difference between the front of your face and the side of your face to you?
When you illustrate it, there would seem to be. My statement was completely different. I didn't see a difference.
And you're indicating in this statement, and again, we're still just talking about Detective Proctor's statement, that you were hit so hard that you were dazed.
I think dazed, surprised, shocked, all those things would fit that, yes, sir.
Okay, and you yourself said in a tape statement that you bruise easily.
On my arms and my, yes, sir.
Okay, and you heard Jennifer and Matt testify you bruise easily, correct?
Yes, sir, that's correct.
All right, so here's what you're testifying to. You're testifying that there's I think it came out as 6'4", Chad Oulson, who's full of rage, is virtually on top of you, and he punches you or hits you hard with a cell phone, so much so that you're dazed, yet you easily bruise and there's not a single mark on your face. That's what you want this jury to believe?
Yes, I do.
Not a single swelling, not a single red mark other than your left eye lid has a little bit of redness on it. That's the extent of the injuries a 6'4" person put on you when they hit you hard enough to daze you, correct?
And knock my glasses off, yes, sir. Or, I'm sorry, askew would be the right word.
And you remember listening to your own witness, Dr. Adams from the medical examiner's office, who talked about all these bony parts and their skin, and the skin's so thin on the side of the face, and you'd expect all these traumas, yet there's not a single mark on you from being punched.
I disagree with the single mark comment.
And everything that we just described isn't even visible on the video, is it?
It was a perception on my part. I was scared. This guy was completely out of control. Didn't seem to be acting rational. I was so scared until I was not sure exactly where he was, but I knew he was attacking me.
Okay. So your perception was an attack that never occurred?
That would be a misstatement to say it never occurred.
Okay. Well, the video's in evidence. The members of the jury can review the video. And you would believe that you were in a life or death struggle prior to the shooting?
Yes, sir.
May we approach her?
Yes.
Now the prosecutor was really starting to cook with some gas. Let me bring in my guest on the program, criminal defense attorney Josh Schiffer. He's standing by in Atlanta. Josh, I would have wanted to see some of this first. It seemed like the prosecutor was really getting to the heart of the case just there in that line of questioning before that pause in another sidebar. Yeah. Your thoughts?
Yeah, and that pattern, the pounding, the actual cadence of the trial gets interrupted with these sidebars. And like you're saying, we start getting going. Everybody's attention peaks up. Your heart begins pounding. Your senses start tuning in because you're talking about what really matters. And then there's this pause. Mm-hmm. The pause, the silence, it upsets your ability as a juror to really pay attention. It changes the emotion, and it can be the exclamation point on a particularly valuable piece of testimony. And what we're seeing here now, I think the state's doing a really good job. I think the defendant has actually improved here over the last little bit in the eyes of the jury because he's being a little bit more reasonable. And I think he's showing the state is not floundering, but searching for answers they already know and trying to do the setup. And juries are really aware of that. They know when a question is a setup or whether this is something that's a softball or meant to trip you up. And I think juries look at that sometimes and get kind of upset at the questioner.
Yeah, they sure do. Josh Schiffer, so glad we have you today on the program. We're going to squeeze in a break. Stand by. We're hitting the pause button. They're at that sidebar anyways. As soon as they're done with it, we're going to see more of the cross-examination of the defendant. Former police captain Curtis Reeves now finds himself on the other side of the law. We know a homicide happened, but the question is, was it justified? We'll be right back.
We've all been there.
Into the courtroom we go in Florida. We're in Dade City, which is halfway between Orlando and Tampa. It was in Tampa where the defendant was once a police captain, so retired at a very, very high rank. Now he's finding himself on the other side of the law. He is the accused in this case. The state's accusing him of the crime of murder. He says the shooting was in self-defense. We're going back in now for more of the state's cross-examination. It was really heating up. The prosecutor was asking some really great questions just before they took a sidebar. Take a look.
Today you're testifying that there were 2 attacks and that the first attack happened immediately when you got back from the manager, correct?
As soon as he jumps out of his chair, yes, sir.
Okay. And may I have the witness step down, Your Honor?
You may.
And I'm going to need to move this up.
I can see on the screen. I'll stay here.
Everybody see? More this way. Okay, so everybody see? Okay, so your testimony is today you came back from the manager, okay? Okay. So this is you coming back from the manager, correct?
Excuse me, Mr. Rosenwasser, what exhibit is this?
This is State's Exhibit number 2.
Thank you.
Thank you. Okay, so here, this is where we see you coming back into the screen, correct?
I'm coming back into the screen, I'm not sure. Okay.
Now you sit down.
Yes.
You cross your legs. Now your testimony is this is when you're attacked, correct?
Yes, it's right after I sat down, yes.
Okay, and right here, I don't know if anyone, can you all see this?
Yes.
I don't know if it's better to use the pointer or the laser. Okay, right here, you see where this is?
Yes.
Okay, that's Chad Oulson, correct?
Yes, right there.
Okay, so let's keep an eye on Mr. Oulson. And I'm just rocking this back and forth. You see him turning around in his seat here, correct? He's just swiveling at the hip as he's looking back at you.
All I can see is a head and an arm. I'm sorry.
Okay, well, I mean, your testimony was that he was standing up and he attacked you. But if you look at the video, doesn't it look as though he's turning in his seat?
He turned in his seat and jumped up. I don't...
Okay. Well, your testimony was at this point, the implication was, based on what happened during the trial, was that this light right here that's attached to your shoe was supposed to be the cell phone, possibly. So it's at this point in time that your testimony must be that you're being attacked.
I am being attacked right now. Whether the white light is a cell phone or not, I have no idea.
Okay. Now, let's watch this. So this is going forward. Okay? Now, at this point, and this is the loop that was admitted as defense exhibit, at this point,
Judge,
you're saying that...
I object. That is not the loop that we admitted. That is completely different. Ours was done by our expert.
All right,
Okay.
then,
I'll rephrase it.
okay, thank you.
This is our video, of course. Obviously not the loop that was your defense exhibit, okay? What I meant was this is the period of time that's depicted on the defense exhibit. Now, you're telling this jury that at this point in time, a cell phone was thrown at you, correct?
Yes, sir.
And your testimony was that at this point in time, Chad Oulson is standing up and threw his cell phone at you and hit you in the left side of your face.
At this point, I'm hit in the face. He's turning and standing up. I think you're showing microseconds down there. In my mind, it was all one move.
Okay, in your mind, it could be all one movement, but when you look at the video,
You can't tell.
You can't see it because it didn't happen.
You can't see it because he's not on the screen.
Right. So if he's not on the screen, he's not attacking you.
If he's not on the screen, he's off the screen.
Exactly.
Has nothing to do with whether he's attacking me or not.
Okay, so you're saying that when he's off the screen here, this is when the cell phone comes flying at you.
I think we've been through that, but at this point in time, it looks like a big distance there. We're looking at, I'm thinking 12 to 15 inches is where he's at. He's just right on the very edge of the screen.
Okay, I understand that. Okay. Did he punch you with the phone in his hand, or did he throw the phone at you? Because I think your testimony was that he punched you with the cell phone.
I wasn't sure because it happened so quickly.
Because clearly, in looking at the video, there's no part of his body striking your face. Right? Because as you indicated, he's not even in the frame.
Okay, you threw it.
All right, so what you're telling this jury is that Chad Oulson threw his several $100 iPhone at your face.
That would be a reasonable expectation.
Okay, and obviously for you to fear for your safety so that you have to shoot Chad Oulson later on, that cell phone had to be thrown pretty hard at you, correct?
It was, yes.
Okay, yet you don't have a single mark.
Judge, I'm going to ask an answer. That was 20 minutes ago.
Yes, ma'am.
Well, Your Honor, this was a completely separate incident that Mr. Reeves was testifying about. That's the reason I'm going into this particular cell phone. This is a different incident.
All right, just continue.
So you're indicating that he threw it at you now, he didn't punch you with it, yet you don't have an injury consistent with being hit with an iPhone at such a great speed that you'd be later concerned for your safety.
I have on glasses that absorb the impact. That's my only thought. They knocked the spew on my face. Perhaps it was a glancing blow. I was hit in my face.
Okay.
Chad Oulson.
Okay, and the glasses that we passed around to the members of the jury, they rest on your nose like all other glasses, yet you didn't have any markings from the part that holds the glasses close to your nose either.
I didn't see that on any of the photographs.
Right.
You guys speak up, Mr. Oulson. Please, I'm sorry. Please speak up.
Okay, I'm sorry.
Can't hear you. It's right here for you, okay?
Okay. All right, so now let's talk about what happens next. Your testimony was that Nicole Oulson is now standing up trying to hold Chad Oulson back.
I don't think I ever said Nicole standing up.
Okay. Is your testimony that at any point in time after this, Nicole Oulson is standing up, holding Chad Oulson back because he's raging towards the seat?
My focus was on Chad Oulson. She had a hold of Chad Oulson. I have no clue whether she was standing, partially standing, sitting, I don't know.
Okay. Did you ever see Nicole Oulson trying to hold Chad Oulson back after the cell phone's thrown at you?
I did.
Okay, and she's holding him back because your testimony was that he's coming to get you, and he's this raging guy with a contorted face, right?
Yes.
Okay, and now you saw the video where you were walking into the theater. We did that early on. You remember that? Okay. When you were walking into the theater, was there a fight happening in the theater?
Here I'm walking at?
Right.
No, there's no fun.
Okay.
I don't know what was on the screen, but...
Okay, I'm not talking about the screen. I'm talking about people in the theater. There wasn't a fight or something crazy going on, right?
No.
Okay, and here's what I'm saying. When you're walking into the theater, this motion-activated camera picks you up just walking with your wife casually to sit down in a seat, correct? You saw that?
I did.
All right. Now, you want this jury to believe that Nicole Oulson is holding Chad Oulson back, and he's raging to come at you. During the time period that this motion-activated camera isn't picking it up.
Objection, Your Honor, improper predicate. It's not picking up anything in row B. Anything in row B.
No.
That camera's picking nothing up in row B.
Excuse me. We can approach. No standing objections, please.
Can we approach?
Yes. And what is...
Oh, yeah, we've seen a lot of what are called speaking objections. So under the rules of evidence, the way it's supposed to be done, you just stand up and you say objection, and then the court will say basis, or sometimes courts prefer to just say objection and state the basis right then. Basis could be, for example, hearsay, calls for speculation, relevance, things like that. But when you just stand up and say, objection, Your Honor, I don't like the way that this video is showing this and this is unfair. No. That is not allowed, not permissible. And so this is why the court is asking everybody to go to Sidebar and talk about what the issue is. Let us know what you think of this cross. We're getting a lot of tweets from you who see it both ways. Many of you saying Curtis Reeves is doing a great job helping himself. Others are saying not so much, and the prosecutor is really on fire. Keep them coming. Stay right here with Court TV Live.
Tonight at closing argument.
for being with us on this Thursday afternoon. I'm Julie Grant. Let's go back into the courtroom together now and see more of the cross-examination of defendant Curtis Reeves.
Hearing page 1867 and 1868.
I'm going to object. What's the question?
I'm addressing what you...
What is the question?
Okay, conclude. Look at it.
Oh, Josh, I wanted to see more. The prosecutor was on a roll there, and like you said, these pauses really just kind of deflate the momentum, of the situation, don't they?
It slows it down.
Yeah, no, it really does. I had a comment on Twitter. Somebody said that they felt that this cross was a bit disorganized. And I do agree with that, because it seems like the prosecutor is jumping from subject to subject. And while he's making some good points, he keeps sometimes going back to something he already addressed. What do you think of it, looking at it from the standpoint of somebody who knows what it's like to be in trial and go up against a prosecutor in a case like this?
Yeah, the Twitter conversation's fascinating because you get all these great perspectives of people who are pretty similar to jurors. And this has been very reasonably disorganized. There wasn't this, here's the one theme, we're going to stick with the theme, we're just going to talk about the one theme, beat it, beat it, beat it. No, this has jumped around a bit. That's because the state, I feel, is doing a good job exposing the personality of defendant Reeves, because his personality is at heart of this. Is this gentleman a weak, feeble, scared, intimidated, older gentleman who needed to use his firearm, or is he still the sophisticated, knowledgeable officer with deep experience who knows more than anybody else walking around about the use of force and when you're allowed to pull out a gun or not? And I feel one of the mistakes in this trial has been he kept enough of that police officer personality on this cross-exam. He's the defendant. He's not the cop anymore.
Exactly. Josh, thank you so much. Sidebar broken up there. Let's listen.
Regardless, it's an unrecorded section that wasn't picked up by the motion detection system. You recall that? Okay, so during this section, this blue section, was Nicole Oulson trying to hold Chad Oulson back, and he was pulling away from her. He looked as though he was out of control in a fit of rage, trying to get over the seat to you.
During that brief period of time, she had a hold of him when he jumped up and turned. I didn't see her. I was only stalking.
Okay, what I'm asking you is this. During this period that was not recorded by the camera system, was Miss Oulson trying to hold Chad Oulson back because he was trying to get over the seat to you?
She had a hold of him when he first jumped up. I would assume she had a hold of him then.
Okay. Would it refresh your memory to take a look at this hearing?
Sure.
Bottom of page 1868.
Yeah, that's pretty much what I said. She had a hold of him before he jumped up. She had a hold of him while he was standing up.
So Chad Oulson was pulling away. He looked to you like he was out of control in a fit of rage, trying to get over the seat to you.
Yes, sir.
Okay. Yet, my point being, when you're walking into the movie theater, the camera system is picking up just you and your wife walking in, correct?
When I first got there.
Correct. But this description that we just talked about, the way you're portraying it, he's trying to get over you, and she's holding him back. The camera system doesn't capture that. Yet it can capture you just walking in the movie theater calmly.
It doesn't capture anything on there, brother. camera system.
Okay, it doesn't capture it on your row. There's nothing captured here. The camera isn't picking anything up. There's no significant movement. It's not that it's not capturing the row, it's capturing nothing. Isn't that correct? The blue screen is not capturing anything at all.
I see. It's not detecting motion, is that what you're saying?
Correct. You're portraying this, that Nicole Oulson's holding Chad Oulson back.
He's trying to answer, and it's one interruption after
It
another.
hasn't. I'm sorry.
No, I'm listening.
It doesn't key on their row at all.
You're right. But when you're looking at this blue screen, which is a black screen in your video, it's not keying on any row because it's not detecting any motion. Isn't that correct?
I'm stuck to my seat, yeah.
But you're saying that Nicole Oulson is fighting with Chad Oulson, who's trying to get over the seat, yet it's not recording any motion.
Their row does not trigger, in my mind, does not trigger the camera in that row. If it did, we'd have full view of everything that he did.
No, the reason you don't have a full view of everything he did is because
Objection,
you
Your Honor,
can't.
that's not a question. That he is argumentative at this point.
Isn't it true that the reason you don't see that row is based on the camera angle? Has nothing to do with the motion activation system?
It has to do with the fact that they're on the very edge of the camera system. I have no idea how it works.
Oh, this cross is getting so good. And here's the best news. You're not going to miss a moment of it. We're hitting pause, heading to a break. Stay right there. Ashley Wilcott will be here next. My time is done. Big thank you to criminal defense attorney Josh Schiffer for coming on the program today. I'm Julie Grant. It's been great being with you.
The following information is
Your Medicare needs are. Call United Healthcare now. Count on us to have more for you.
He was so much above me and so full of rage, I guess you could say, that he was going to strike me with all the strength that he had or he could put together. I figured that this was the end of the line for me.
We are following several major cases this afternoon, including the movie popcorn murder trial in Florida. The defendant, Curtis Reeves, took the stand in his own defense today. Is he going to regret that decision, or will it set him free? We will hear some of his testimony in a moment as he concludes. And new developments in Kentucky, where former Louisville police officer Brett Hankison is on trial for charges related to the botched raid at the home of Breonna Taylor. We'll keep you updated as that case develops. And moving to St. Paul, Minnesota, we're on verdict watch in the trial of the 3 former officers charged with violating George Floyd's civil rights. We'll go live to that courthouse when the jury reaches a decision. Welcome back to Court TV Live. Good Thursday afternoon. I'm Ashley Wilcott. Thank you for joining us this afternoon. Now, as I mentioned, Curtis Reeves is still on the stand. He's gone through direct testimony, and now he is being cross-examined by the prosecution in this case. Do you think they're doing a good job or not convincing this jury that he, in fact, did murder the victim in this case? We want to take you back to that courtroom. You haven't missed anything for continuing cross-examination.
Remember when I was asking you questions about your left hand? And if you're shooting, I use the term shooting from the hip, it's incorrect, but we were talking about where your left hand would go, that to keep it out of the muzzle path, that you would put it close to your body.
That was I've never done.
Correct, okay? Now, do you see your right hand here? Your right hand has a firearm, correct?
Yes, sir.
Okay. Do you see your left hand?
No, sir, I don't.
Okay. Right here.
That's the right hand, right?
No, your right hand is going to be with the gun. Okay. And if you look to the left side of your body, you'll see your left hand.
It's not, I guess, I don't know where it's at. It's not in front of me.
Okay. So you don't see it go over towards your chest?
I see my hand moving because I'm being attacked. I don't know which way it's moving. I mean, it's moving all around. If you look, I don't know, it's in my lap perhaps.
What's in your lap after you bring it over from your left side, which is exactly what I'm asking you.
I did not consciously grab a hold of my chest. That's the only answer I can give.
You did it instinctively because it's part of your training?
No, we have never trained to grab a hold of your chest.
I'm not using the whiteboard anymore.
Okay. Thank you. Mr. Martin, can you guys push it back a little bit further so I can see the podium? That's good. That's good. Thanks.
Just a couple more questions about that particular scenario. When you came back from the manager, when did you grab your popcorn? Immediately when you sat down?
Yes, I was sitting down, yes.
Okay, so before you were struck with the phone?
Before I was what, sir? Before what?
Before you said you were struck with the phone, you grabbed your popcorn?
Right, yes, sir.
Okay, but your popcorn doesn't spill when you're struck with the phone very hard, does it?
I can't see that either.
Okay. Now, I didn't show you the videos are in evidence, but let me ask you this. If a phone's thrown at you that hard, how is it that you keep going forward after the time the phone hits you? I mean, wouldn't you agree with me that generally when someone's hit hard with an object, they react, that they put their hands up to where they were hit, or their head goes backwards, they make some type of reaction. Why is it that you don't react at all once you're hit by this cell phone so very hard?
I can speculate and say that I had karate training, I had grappling training. When you're involved in a life or death struggle, you don't take time to grab your face. You need to defend yourself. After it was over with, I've replaced my glasses and checked my face.
Okay, so just my last couple of questions. You remember when you were sitting in the cruiser, Detective Proctor's cruiser?
Yes, sir.
Okay, and he asked you a whole series of questions to go into detail about what occurred, correct?
I don't remember those detectives asking me very many questions at all.
Okay, but we have a transcript for it, and we have your voice, correct?
Right.
All right. And when he came back to talk to you a second time, he said, look, and I'm paraphrasing, Curtis, if there's anything else you have to tell me, right?
Yes.
You remember that?
Yes.
When you were sitting in the back of that cruiser, and now we're talking about this hit that you're so certain of, that it glazed and it was just a terrible hit. You remember when you were in the back of that cruiser and you said, as I'm sitting back in here, I'm second guessing myself.
Oh,
did
yes,
he
sir.
even hit me?
Yes, sir. I second guessing it for the last 8 years. Anybody that's involved in something like that and they don't second guess it, it's got to be nuts.
Okay, but what I'm asking you is not if you second guessed that. You second guessed the very fact that you were even hit.
I second guessed every step of that encounter. Yes, sir, I did.
Do you agree with me it's not good to second guess whether or not someone ever hit you, or even second guess yourself when you shoot and kill another person?
I think that if you are human and you have respect for human life, you would always second guess yourself constantly.
You second guessed this very hit that you testified to.
I second guessed this entire event.
I understand. I don't have any further questions.
Thank you. Redirect.
Yeah, just briefly, Your Honor. Mr. Reeves, let's go from the beginning of the prosecutor's cross, just briefly. He indicated that you were able to do all these things despite your current condition. Would you tell the ladies and gentlemen of the jury if you have a handicap sticker on your car?
Objection, this is not relevant to 2014.
Oh, yeah.
No.
And while they approach, I want to bring in our guest legal analyst today from St. Louis, Missouri. We have trial attorney Alicia Dern. Alicia, on cross-examination, the defendant was very clear. He said, and I think this is a quote that I'd written down and was looking at our notes that said, I intended to shoot him. Did you shoot him out of blind fury? No. Was it an accident? No. I killed him out of fear. Do you think that his testimony has been credible thus far?
Well, I actually do think he's looked pretty credible so far. He's been very honest about his confusion, about second guessing, about the things that were going on in his mind immediately during and immediately after. And he's not trying to hedge against the cross-examination. And I think that is actually helpful for him.
Yeah, I don't disagree with you. And I want to, right here, we have a picture. This is live court. And that, of course, is Nicole Oulson, Chad Oulson's wife, in the green top with the blonde hair. Looks like she's physically reacting, perhaps upset, hard to tell. But you can see they've approached yet again. And there we have another good shot, because that is the defendant's wife. She has been in the courtroom throughout this trial. That was an agreement between the prosecution and the defense. The other witnesses could not be in the courtroom. They allowed her to stay. knowing that she would testify, which of course she did testify. Also part of this testimony, and we were having a discussion about in terms of his testimony, what he's changed, what he hasn't changed. I think the prosecution has done an effective job, Alicia, of going through what his prior statement said and trying to get him to contradict it or trying to impeach him with it. But do you think they made much headway in that department?
Well, I mean, the fact that he didn't immediately check his face, the fact that he immediately was questioning whether he was hit at all, is going to certainly be an interesting question for the jury to weigh when they're looking at his credibility. But no, I don't think it was as damaging as they had perhaps hoped it would be.
Yeah, I don't disagree with you. I didn't find it so either. We are going to take a break, but don't worry, you will not miss a thing. We will pick up right where we're leaving off, so we continue to hear cross-examination of the defendant. He finally speaks. We'll be right back on the other side.
Police officers shot and killed
want to take you right back into that courtroom in the state of Florida. Curtis Reeves is finally speaking. He's on the stand. He had cross-examination and now, rather direct examination, and now cross-examination. And he just admitted to the prosecution he does second guess what happened that day every day. So we're going to go back. You haven't missed any of his testimony to pick up where we left off.
Currently have, correct?
Correct.
Tell the ladies and gentlemen of the jury why you do all those things.
Your Honor, I'll just object to the time frame that we're talking about. It doesn't matter what's happening.
2013, 2014, those 2 years.
Yes, sir.
Tell the jury why you do those things.
To try to maintain a level of fitness as I get older, keep my joints. I do range of motion exercises. I rode bike. I used an elliptical. I tried to do it 4, 5, sometimes 6 days a week. I pick up, instead of using a pitchfork to pick up things in the backyard, I use my hands to bend over and pick them up. It exercises my back. I wear a back brace when I mow the yard. So that I don't get jerked around while I'm riding the lawnmower. So that's what I've always done. Like when we shoot sporting clays, we walk for the physical exercise.
Do you just want to stay home and sit in a chair all day? Is that what you want to do?
No, sir, I don't.
Do you ever want to be at a point in your life where all you do?
Objection, relevance.
Do you ever want to be at a point in your life where that's all you're able to do?
No, sir, I'm not looking forward to that at all.
Now, the prosecutor showed you and the jury 2 photos. Can I approach? One was, I want you to read that exhibit number for the jury.
The ID number or the evidence number?
The evidence number.
The evidence number is 9-1.
9-1. Okay, so we're going to put 9-1 here. Now I want you to read this exhibit. These are the 2 exhibits that we passed around to the ladies and gentlemen of the jury. Read the exhibit number for that one.
7-3.
7-3. Let me give you one more. I want you to read that 9-1 is a part of a composite, okay, exhibit. I want you to read all of the numbers in this composite.
Each one of those that are
each one of
together. 9-6, 9-5, 9-4, 9-3, 9-2.
9-2. And so the 9-1 that you mentioned earlier goes with that composite, correct?
Yes, sir.
Okay. So now, may I ask the witness to step down?
Sure.
Now, Mr. Reeves, I'm going to show you what's 9-1. That was the one that was shown with the 7-3 photo, correct?
Yes, sir.
Okay. So let's look at that. Hold it up for the ladies and gentlemen of the jury. I'm going to show now 9-2. You see 9-2 there?
Yes, sir.
Okay. Do you see a hand coming in that direction?
Yes, sir.
Okay, let's put that behind your fingers there.
Yes, sir.
Let's look at now 9-3. You see 9-3?
Yes, sir.
Can you point out to the ladies and gentlemen of the jury a hand?
Yes, sir. It's right here.
Okay, let's go to 9-4. Can you show the ladies and gentlemen of the jury the hand there in 9-4?
It's all the way across, right up against my face, looks like.
It's a progression in the composite, correct?
Yes, sir.
And let's go now to 9-5.
Yes, sir.
Can you look and show, ladies and gentlemen of the jury, the hand there at 9-5?
Yes, sir. It's all the way across again up against my face.
And then finally, let's go now to 9-6 and show the hand to the ladies and gentlemen of the jury.
Yes, sir. It's still in contact right there, all the way across, right over the top of my wife's head.
And that was the popcorn incident, correct?
Yes, sir.
Okay, so now let's go to 7-3. Stay right there, please. 7-3, what you testified in cross-examination was the first attack, correct?
I think so, yes, sir.
Would you show the ladies and gentlemen of the jury Mr. Oulson coming over his seat in the first attack?
I do.
You may take your seat. No further questions.
May this witness be released? Or are you done with them?
Yes, yes.
You can have a seat, Mr. Reeves. Counsel approach.
And he has finished testifying. The defendant, you can see him there on your screen, walking back to his chair, using his cane. Again, he just, all day long, he has been testifying. Direct examination followed by cross. Alicia Dern still with us today, trial attorney. Alicia, at least 3 times during cross-examination, he was made to exit the witness stand, use his cane, come down the steps, stand, testify, and go back. And I believe that happens one other time. So is that strategic by the prosecution, do you think?
Possibly. I was actually wondering about this because I thought that it was less effective than putting the images up on perhaps an overhead for the jury to really see them. So whenever you're holding pictures in front of the jury and pointing, it's going to be difficult for the jury to see some of that detail. And having him get up and down using a cane, you know, I don't know that that's helpful for the prosecution because it's really undermines the fact that he's an older gentleman, that he is a little infirm, and that might actually help them with the reasonable doubt as to his state of mind as to fear. So I don't know that this helps the prosecution at all, even though he's getting up and down.
Yeah, I think it could cut both ways. One is he's mobile, he can move around. On the other hand, you're right, he has to use the cane and it may add to the belief of his infirmity. Let's go, it looks like the sidebar has concluded. Let's go back to court.
Mr. Escobar.
The defense will rest.
Thank you. All right, ladies and gentlemen, obviously you heard the defense rest.
The defense rests. They are done with their case. That was the last witness. Primacy and recency. Alicia Dern, I think, is still with us to talk. Alicia, primacy, recency, is it the right move or not for a defense attorney to end with the defendant as the last witness?
With this particular witness, I think this was an intelligent move. He came across pretty well, and I noticed that he was comfortable turning and facing the jury and looking them in the eyes when he was speaking with them, and that's going to be the last thing that they remember. So, you know, they've already seen the prosecution's case. May have made up their minds, and then you have this defendant get up and talk in a way that appears sympathetic and credible, and maybe that's what they needed for their reasonable doubt. And that's going to be what they're going into closing arguments within their minds.
And we know the history of the case is that this defendant tried to claim the stand your ground law in Florida. That was not successful with the court. Therefore, this prosecution has to prove murder in the second degree, but they also have a lower burden, but they still have a burden of proving to the jury that he did not kill in self-defense. What is your analysis? Do you think that they have met that burden, or do you think there's reasonable doubt?
Well, I think that there's reasonable doubt here. Now, on first blush, killing somebody, shooting somebody in reaction to them hitting your popcorn seems like an outrageous overreaction. And so I think if it were a younger man, if it were somebody who had a history of being more hot-headed, that it would be a little bit easier on the prosecution. But you have here somebody who is stating in a way that appears credible that he had fear, that thought he was acting in self-defense, and if that is reasonable, then the jury may determine that he's met his burden and that the prosecution hasn't proven this beyond a reasonable doubt. I think this is kind of a hard case for the prosecution.
I'd like to take this opportunity because one of the things that people raised in talking about whether or not this was self-defense is the size of the defendant. Let's listen and watch to some of his testimony when he was actually standing next to the prosecutor.
Looking at Defense Exhibit 7-3, which is the top one, and looking at Defense Exhibit 9-1, which is the bottom one, you'd agree with me that they're in two different positions?
Yes, both of them.
Okay. And that in 7-3, he is turned around in his seat, meaning sitting down, which is consistent with your original statement to Detective Proctor.
The location of the camera and the angle that the camera's coming at gives you a misperception of where he's at.
Alicia, how powerful is that image? You just saw the prosecutor, and really on all sides behind him, next to him, you could see the defendant. He looks like a very large man, and the jury's watching that.
I think there's definitely something to be said about his size. Again, this might be offset by his age. Of course, a lot of years have passed since the incident, but just the same, this prosecution definitely looks like a small man in comparison. I mean, he's very broad-shouldered, he's tall, and that may show that perhaps he didn't have a reasonable belief of fear because of how large he is.
But he did on the stand describe the victim in this case, Chad Oulson, as a giant. And we know that, in fact, Chad Oulson is 6'4", the defendant 6'2". You're going to stay with us. Coming up, we're going to check in on a couple of other big cases, the George Floyd civil rights trial in Minnesota, and we'll turn our attention to Michigan for today's hearing involving the parents of the accused Oxford school shooter. James and Jennifer Crumbly may soon find out if they are going to trial for involuntary manslaughter, and we will listen to some of today's testimony.
So at the end of first hour, I just looked up different types of .22 bullets, and I guess the teachers can't get their eyes off my screen, SMH.
What does SMH mean?
Generally it means shake my head.
Okay. And what was Jennifer Crumbly's response to that?
LOL, I'm not mad. You have to learn not to get caught.